Let's make sure we have everything on the record, please.
Please don't talk. Wait.
Yeah, so when you say things like that, she can't take it down. So hold on a minute until she's ready, and then she can take it down.
All right, I'm ready. Thank you.
All right, Ms. DuBois, your opening statement.
Before we proceed on the actual merits of the eviction suit, I would like to present plaintiff's motion, Estancia Villas LLC's motion for immediate possession under Rule 510.9C. We did file the notice of rent default and request on January 9 of 2024.
All right, for everyone's benefit, if you could please just explain
Course, Your Honor.
the consequence of your request so that Mr. Waeh understands exactly what you're asking and how it relates to what we're doing today.
Of course, Your Honor. So as the court is aware, this is an eviction. It was appealed from the Justice of the Peace Precinct 3 here in Travis County. Judge Holmes in JP Court entered judgment on November 16. The defendant, Mr. Waeh, appealed that judgment by filing a statement of inability to pay under Rule 510.9C of the Texas Rules of Civil Procedure. However, that rule, 510.9C 5B1, does require that the defendant, within 5 days of filing that statement of inability to pay, deposit 1 month's worth of rent into the court's registry, that being the Justice Court's registry. And if they fail to do that, then the plaintiff is entitled to request a writ of possession. Mr. Waeh did not make a payment into the Justice Court registry. However, the writ request in JP Court was not issued for reasons unknown. On November 28, after the Justice Court case was docketed in the county court, Mr. Waeh had continued responsibilities to pay rent as it becomes due into the county court's registry. That's under Rule 510.9C 5B2. Mr. Waeh did not make a rent payment into the county court's registry by December 6 of 2023, which is required under the rules, as well as the Texas Property Code. Mr. Waeh also failed to pay any rent into the county court's registry for the month of January, which would have been due January 6. In addition, no rent has been paid into the county court's registry for the month of February 2024. Again, an amount of $1,356, which is the monthly rent, would have been due at the Justice Court level, as well as the county court level on January 2023, would have been due January of 2024, February of 2024, as well as December of 2023. No payments have been made. Therefore, the plaintiff in this case is entitled to an immediate writ of possession under Texas Rules of Civil Procedure 510.9C.
All right. Mr. Waeh, let me first ask just a factual question, and then I'm going to let you respond to her request. The factual question, again, this is just a yes or no question. Have you made a payment into the court registry, either the Justice Court or the county court, of any money whatsoever? In what amount? And if so, in what amount did you make it? So
not to the Justice Court, not to the county court.
Okay, so you've made no payments.
$0, $0 and 0 cents.
Okay, all right. Now, if you would like to respond to her request, this is your opportunity to respond only to her request for immediate possession only. Just that part of it.
So they draft the petition. On the petition, literally, they say that they have the exact amount that they claimed in rent. And I have a document. It's time and date stamped. They went there and they said that, hey, I have the exact amount claimed. They next proceeded to attempt to evict me for right of possession only while having all the rent. So literally the moment that they evicted me and passed the petition, they had already
Your Honor, I'm going to object to Mr. Waeh's testimony right now. This is not the merits of the actual eviction.
So he's
to respond.
You can calm down right quick.
Stop. I got this, Mr. Waeh. I got it. I don't take what he's telling me as testimony. He's not under oath. I've not sworn him in. He's not giving me testimony, and because he's representing himself, he gets to make argument in response to your request. But let's be clear, what he's telling me is not evidence, will not be considered as evidence, because he's not yet been sworn in, and he's not giving me testimony under oath. So now, I'll overrule that objection then, Mr. DuBois. However, Mr. Waeh, let me ask you to focus, because I'm only asking you to respond very briefly to her request. I'm assuming you want me to deny her request. Let's start there, correct?
Yes.
All right. And my question really is more in the nature of a response to her legal argument.
Exactly.
Just to be clear, what she's saying is, under the law, she's entitled to this, her client is entitled to this writ of immediate possession because you have not, under the law, paid into the registry of the court your monthly rent as it became due in the court. So she's saying you didn't pay it in December, you didn't pay it in January, and you haven't paid it in February. And because you failed to make those payments into the registry of the court, she says she's entitled on behalf of her client to the writ of immediate possession. My question is, since you've told me you've not made any payments, my question is, why is her legal argument incorrect?
Perfect. 4 points. Original petition. 1, they had already claimed all the rent at the time they filed the petition. It's documented. I'll show you an exhibit later. The next thing is they're not suing for any attorney fees or applicable attorney fees. The third thing is they're not suing for any unpaid rent. The last thing is they were only suing for right of possession. I only appealed the decision because they didn't have any merits to evict me in the first place. Now, let me get to my next point. The fact that they were only suing for right of possession, and I confirmed this with the judge, and literally there's 2 documents where they tried to change it up last second. I wasn't required to pay anything because my statement of inability to pay was substituted for whatever document in conjunction with them not requesting any money for rent. So the fact that they only asked for right of possession, and you can confirm this with the JP court, and I also have documentation I'll show you later. That's the reason why I'm not entitled to pay any rent while we're debating and civil litigating right now.
All right, thank you. Ms. Du Bois, your response to his, or your reply rather to his response.
Your Honor, my client is seeking possession of the property as well as back due rent in this case. He filed an appeal on a statement of inability to pay rent. There's been no payments into the registries of the court. The rules require that the court issue an order entitling my client to possession and immediate possession. So this is a non-payment of rent case, Your Honor. My client is seeking possession of the property as well as rent. Mr. Waeh, by filing that statement of inability to pay, had a continued duty to pay rent to the court's registry and failed to do so. So my client is entitled to a writ of possession.
All right, thank you both. I'm going to hold my decision on this issue until I've heard the rest of the case. So I'm not going to make a ruling on it at this time. I want to hear the rest of the argument and see what the evidence shows, and then I will make a decision on the request related to the immediate writ of possession. I'll save what I think about that until that time. So let's move on. I'll carry this forward as we continue the hearing on the merits and move to opening statements. Again, 1 or 2 minutes just on what it is your request for relief is, because I already understand the nature of the case is an eviction. I understand there are issues related to both rent and possession, and I understand more now than I would normally have in an opening statement. So very briefly, please give me your opening statements, beginning with Ms. Du Bois.
Yes, Your Honor. Again, this is an eviction based on non-payment of rent. My client, Estancia Villas LLC, is seeking possession of the property located at 1200 Estancia Parkway here in Austin, 78748, and that's apartment 625. My client is seeking an award of back due rent here today, and the evidence will show that Mr. Waeh has failed to pay rent beginning September of 2023. The evidence is going to show that my client has a superior right to possession of the property and that they are entitled to their reasonable and necessary attorney's fees here today. That judgment for the back due rent owed through February of 2024 and their costs of court.
All right, thank you. Very briefly, Mr. Waeh, your response just to the, not your response rather, but your own opening statement, both in connection with your defense of the claims against you as well as your counter petition against them. But very briefly, just a couple of minutes on opening. Basically what I'm listening for is, what do you want the court to order at the end of the day?
I just want to take 5 seconds to point out Aaron's body language.
No, you don't get to do that. No, you don't get to do that. You get to give me your opening statement. You don't get to comment on appearance.
I can do opening
Excuse me. Yeah. We don't make personal attacks on people. I'm not going to let anybody do that to you, and I'm not going to let you do that to anybody else. So no comments on anybody's personal appearance or anything else. Just your opening statement, very briefly.
Yes, ma'am. So I was evicted on November 1st. They had filed a petition. There's multiple documents on file, but basically, again, let me reiterate those 4 points. They had sued me, and on November 1st, I was up to date on rent, and I can show you the document. They're not suing me for, they literally have the document signed as an authorized agent saying that they had claimed rent. I wasn't violating the lease. They weren't suing for any unpaid attorney fees or unpaid rent. And then on top of that, like, basically what I'm trying to get at is the merits at the JP level didn't have any merits. There was no cause to evict me in the first place. The only reason why I appealed was because they sued me for right of possession and won that. But I'm actively suing 6 departments right now because of how they've been handling the cases. Currently, there is some very nasty stuff going on in Estancia Villas. Like right now, they've already updated all the smart locks. They've been monitoring me. The authorized representative.
Mr. Waeh, hold on. Let me break this down a little more basically. I understand that for the reasons you've already articulated, you want me to deny their request, correct?
For right of possession, absolutely.
All right. Now, secondly, you have a claim against them. My question is
Countersuit.
my question's two questions. First question is, what is the claim? That is,
Perfect.
what is the cause of action you're suing them for? And
Mhm.
second question, what is the relief that you want? Like, what do you
For
want
sure.
me to do about it?
I apologize. Here it goes. It's a criminal conspiracy, child grooming, unlawful use of criminal instrument or mechanical security
But
device.
slow down. I need you to slow down. Slow down. Miss Duet is taking it down in shorthand, but I'm taking it down in longhand. So
I'm sorry.
slow down. I got criminal conspiracy. What else?
Child grooming,
Okay.
unlawful use of a criminal instrument or mechanical security device,
Okay, go ahead.
unlawful interception, use, or disclosure of wire, oral, or electronic communications,
Okay.
unlawful access to storage communications,
Okay.
trafficking of a person,
All right.
continuous sexual abuse of a young child or disabled individual,
All right.
indecency with a child.
All right. Anything else?
Yes, invasive visual recording.
Okay. Anything else?
Yes, unlawful disclosure or promotion of intimate visual material,
All right.
sexual coercion,
All right.
unlawful electronic transmission of sexually explicit visual material,
Okay.
aiding suicide,
Okay.
theft,
Okay.
deceptive business practices,
What else?
fraudulent destruction, removal, or concealment of writing,
Okay.
exploitation of a child, elderly individual, or disabled individual.
All right. What else?
Breach of computer security,
Okay.
electronic access interface.
Say it again. Electronic.
Yep, PC 33.022, electronic
I just
access interface.
Interface.
Yes,
Thank you. Anything else?
yep, electronic data tampering,
Okay.
unlawful decryption,
Okay.
improper influence,
Okay.
witness tampering, tampering with a witness, probably the same difference.
Okay. Go ahead.
Failure to stop or report aggravated sexual assault of a child.
Okay.
Abuse of the official capacity.
Okay.
Official oppression.
I'm ready.
Misuse of official information.
Okay.
Harassment.
All right.
Stalking.
Okay. What else?
And there's another one is a 71.02. It's a RICO charge. Racketeering to influence organized corrupt organizations. I said that correct.
All right. And so is that all of the causes of action that you brought against them in your countersuit?
That's my countersuit right there.
All right. And what are the damages? What is the ultimate ruling that you want from the court? And what are you seeking in connection with those causes of action?
My proposed order of judgment is $200 million, and criminal charges be pressed. It's the motion is why there's a motion to escalate to a criminal court, because
So
this is not civil.
slow down. Let's do damages first. You're requesting $200 million.
$200 million. Let me get back to your screen so I can see you. Sorry.
I just want to make sure I understood the number correctly.
Yes, ma'am.
Okay. And anything else that you're seeking in terms of the relief you seek today? You said $200 million in damages, and there was something else.
Yes, criminal charges be prosecuted against the individuals that were involved as accomplices.
Sorry. Let me just be clear. I want to clarify. You're asking me to order that some prosecutor charge them with these things? Is that what you're saying?
Well, initially it was a motion to escalate, seeing as how there's criminal charges, we need to go to district. But if what you're talking about,
Asking you what you want me to do. What do you want me to order? That's what I'm getting at. You want me to order $200 million be paid to you, and you want me to order somebody to do something related to criminal charges. I'm just trying to clarify what that something and somebody is, or might be.
I want criminal charges pressed against all of the representatives in estancia villas as far as management goes.
Okay,
All of them that were
want me to-
involved.
So that's what I'm clarifying. You want me to order the DA to go prosecute them in criminal court?
Yes, and investigate estancia villas. I want an investigation
just
open.
trying to clarify what you want me to do. Anything
I
else
can
you want me
reiterate.
to? No, I don't want you to repeat. I want you to just tell me if there's anything else. I understand you want me to do two things. Well, really three things. One, you want me to deny their request against you. Two, you want $200 million in damages for these causes of action you have spelled out. And three, you want me to order the DA to investigate them and file criminal charges against them.
Got it. That's
All
it.
right. Is there anything else that you're seeking today?
Not for the proposed order of judgment. Deny them, 200 million, investigation, criminal charges pressed.
That's helpful. Thank you very much. And thanks for your opening statements. Let's move on to the evidence phase of our proceedings. Ms. DuBois, you may proceed first with your first witness.
Thank you, Your Honor. I do want to bring to the court's attention Texas Rule of Civil Procedure 510.3E. There are no counterclaims in eviction suits. Those are specifically barred for a number of reasons. Outside of that, Your Honor, I don't think the court has jurisdiction to hear Mr. Waeh's counterclaims.
All right. I'm aware. I
Okay.
want Mr. Waeh to have his day in court. I want him
Understand,
to
Your
get
Honor.
out everything that he wants, and I want to understand what he's asking for. And so, like with your earlier argument on the writ of possession, I'm going to hold on to your request in connection with his counterclaims until we get to the end of the proceeding, when I feel like I have heard everybody, that everybody's been heard, that everybody's position has been understood and respected. And then at the end of the day, I'll make some decision after I sort it all out. But I can't really do that until I've heard from everybody. I want to hear from everybody. I want everybody to have an opportunity to tell me their story, tell me what they're complaining about, tell me what the other side's, what their response is to the other side's complaints. And I want to know what everybody's got on their minds before I make any decisions. Okay?
Understood, Your Honor.
All right.
Your Honor,
Now, you may call your first witness.
thank you, Your Honor. Plaintiff calls Amanda Cantu.
Ms. Cantu, if you would raise your right hand, please. Do you solemnly swear or affirm under the penalty of perjury that the testimony you will give in this cause will be the truth, the whole truth, and nothing but the truth?
Thank you.
And if you could just state your name for the record, please.
Amanda Cantu.
All right, Ms. Cantu, your audio is a little bit hard for us to hear. If you could just get a little closer to the microphone, that would be helpful to me and maybe to the court reporter and to Mr. Waeh as well. Just get a little closer to that microphone, that'd be helpful. All right, very good. Ms. DuBois, she stated her name. You may proceed with your questions.
Thank you. Ms. Cantu, where do you work?
Estancia Villas.
And what is your position there at Estancia Villas?
I am the resident services manager. So an assistant manager.
So you're appearing
Okay,
as
that kind of broke up for me a little bit. I'm so sorry. Can you repeat your answer?
The resident services manager too.
Ms. Cantu, you're appearing as authorized representative of Estancia Villas LLC.
Yes,
Are you familiar with the tenancy of Mr. Alan Waeh?
yes,
Does he reside at 1200 Estancia Parkway, apartment 625, Austin, Texas, 78748?
yes,
And that address is in precinct 3 of Travis County, Texas?
Yes.
Is Mr. Waeh's tenancy there at the premises based upon a written lease agreement?
Yes.
Ms. Cantu, I have forwarded over to you and provided to the court Plaintiff's Exhibit 1. Your Honor, would you like me to share my screen?
I think that would be helpful so that Mr. Waeh knows what exhibit you have marked as one and so forth. I don't know if he's reviewed the box photo or not, so it might be helpful just to make sure we're all on the same page of what document you're asking her about. So yes, please do so.
Ms. Cantu, do you see my screen?
yes,
Okay. Is this a true and correct copy of the lease agreement between Alan Waeh and the plaintiff in this case?
yes,
And is this agreement signed?
yes.
Has this been amended, modified, or changed in any way, but for my marking of Plaintiff's Exhibit 1 and the highlighting?
No,
Your Honor, we're going to offer Plaintiff's 1.
Mr. Waeh, do you have any legal objection to plaintiff's exhibit number 1? I'm asking if there's a legal reason why I can't admit that document into evidence.
No, that's 100% acceptable.
Okay. Plaintiff's exhibit number 1 is admitted.
Ms. Cantu, pursuant to Box C of the lease agreement, what is Mr. Waeh's monthly rent?
$1,356.
Okay. Did Mr. Waeh fail to pay rent in violation of paragraph 3 and 3.5 of the lease beginning September 1 of 2023?
Yes.
Has Mr. Waeh paid any rent to the property for the month of September 2023, October 2023, November 2023, December 2023, or January or February 2024?
No.
Is the failure to pay rent a default of lease under paragraph 23.1A?
Yes.
And does the default of lease entitle Estancia Villas to possession of the premises?
Yes.
Are you seeking an award here today of back due rent?
Yes.
Are you seeking an award of back due rent of $1,356 for each of the months of September 2023 through February 2024 for a total amount of $8,136?
Yes.
Now, pursuant to paragraph 23.5, are you also seeking Estancia Villas reasonable and necessary attorney's fees here today?
Yes.
Are you seeking your costs of court and interest at 8.5% on any judgment that would be rendered?
Yes.
Okay. Now, Ms. Cantu, moving back up to page 1 of this lease. So Mr. Ways moved into the premises sometime in August of 2023, correct?
Yes.
Were you working at the property during that time?
Yes, I was.
Okay. And here, as you'll see, the owner on this lease agreement is Steadfast Estancia VDS LLC. Is that right?
Yes.
Did that entity sell the property to the plaintiff, Estancia Villas LLC?
Yes.
Okay. Ms. Cantu, I pulled up what's marked as Plaintiff's Exhibit 2. Do you recognize this document?
Yes.
Is this a true and correct copy of the deed showing Estancia Villas LLC's ownership of the property?
Yes.
Your Honor, we're going to offer plaintiffs too.
Is there any legal objection, Mr. Waeh, to the deed?
Nah, yeah, they own it temporarily.
Do you have any objection to the document coming into evidence?
I do not.
All right, it's admitted.
Ms. Cantu, I pulled up what's marked as Plaintiff's Exhibit 3. Do you recognize this document?
Yes, I do.
Is this a true and correct copy of the notice to vacate that was delivered to Mr. Waeh on September 21 of 2023?
Yes.
And Ms. Cantu, how did you deliver this notice to vacate?
I delivered it. I went to his apartment to deliver it. Typically, I put them inside the door and tape them. He was actually home and his door was cracked open. So I knocked on his door and he came and was on the phone and I hand delivered it to him.
Okay, so you hand delivered it to him at the premises?
Yes.
Okay. Has this document been amended or modified in any way but for my marking of Plaintiff's Exhibit 3?
No.
Your Honor, we offer Plaintiff's 3.
Mr. Waeh, any legal objection to this document?
Yes.
What is your legal objection to the admission of the document to evidence?
Who is Amanda Cantu?
No, that's not a legal objection to exhibit number 3. The question I'm asking is there a legal reason why the document that's marked as plaintiff's exhibit number 3 can't come into evidence? Does it violate?
Oh, no, yeah, go ahead. Put that in. Yeah, that's all you.
All right, so plaintiff's exhibit number 3 is admitted.
Ms. Cantu, this gave Mr. Waeh through September 21, 2023 to vacate. Did Mr. Waeh vacate the premises?
He did not. I believe it was October 2020.
Oh, I'm sorry. You're correct. So this gave him.
I'm sorry. Can you repeat that answer for me?
He was supposed to vacate by October 21 and he did not.
So Ms. Cantu, because he did not vacate the premises, you proceeded with filing an eviction suit. Is that correct?
Yes, correct.
Okay. Ms. Cantu, have you also had other issues with Mr. Waeh at the property?
Yes, we've had multiple issues with Mr. Waeh. He has made multiple interruptions to our operations, basically, during business hours. He's made multiple just inappropriate accusations and lies about staff members of UDO and Estancia Villas. He's been very harassing to the staff. He's also made other community members feel very uncomfortable. I personally have moved. I've lived who was living in the same building as Mr. Waeh, just downstairs.
Mhm.
And
Thank God.
I have just moved out due to my own safety needs and my son's. I have a child. And I no longer felt it was a safe space for us, which is honestly very sad because I've lived here over 2 years. And for that to be the reason I no longer feel safe here, not alone at home, but also in work, is very upsetting.
Okay.
And I say the same for other members of the staff. None of us feel safe with here.
Okay. Are you aware of an incident that occurred on January 3 of 2024?
So let me interrupt here by saying that unless any of these other allegations are related to the reasons for eviction, I'm going to rule them out of order.
Your Honor, they are. We have pled.
Are they pled in your petition? Because I understood you were asking for a non-payment of rent, a judgment, and
Yes, Your Honor.
interest.
This was originally filed as a non-payment of rent case. However, our supplemental pleading, we have added other defaults of lease concerning Mr. Waeh's behavior.
As long as they're in your pleadings, because if
They
they're
are,
not
Your
in your
Honor.
pleadings, I don't think it's appropriate for us to entertain them. Okay,
I
go
understand,
ahead.
Your Honor, and I apologize for not being clear in my opening, but yes, we do have other reasons for default of lease here, and they are
All
pled.
Okay, go ahead.
Ms. Cantu, do you recall an incident that occurred on January 3 of 2024?
I actually think it was January 5th, but yes, if you're referring to the arrest idea.
Okay, and you just mentioned an arrest. Was Mr. Waeh arrested at the property in January of 2024?
He was.
Okay. Sorry, pulling up my screen. Ms. Cantu, do you see my screen here?
Yes.
I've pulled up what's marked as Plaintiff's Exhibit 4. Do you recognize this document?
Yes.
Is this a true and correct copy of an affidavit for arrest against the defendant, Mr. Waeh, concerning a harassment charge here in Travis County?
Yes.
Okay. Your Honor, we're going to ask that the court admit the affidavit for arrest into evidence.
Mr. Waeh, is there a legal reason why I can't accept this one?
Yeah, it's an ongoing case. It's an active case.
So that's not a legal objection to the document itself. I take your point. I take your point. I take your point that it may not be, shouldn't maybe give it a whole lot of weight, but I think your objection, to the extent that you're making one, is to the weight that I give that document, not to whether or not it's actually admissible. So I will overrule your objection, admit the document, but I will give it only the weight that I think it deserves. For petitioners or plaintiff's exhibit number 4 is admitted.
So, Ms. Cantu, is there other bases for terminating Mr. Waeh's tenancy other than the non-payment of rent?
Other violations of his lease contract, disturbing the comfort of others, disturbing the comfort of the business, criminal conduct.
Okay, and so what you're referencing here, and I pulled up Plaintiff's Exhibit 1 again, is paragraph 11.1 of the lease agreement?
Yes.
Okay, and you'll see here 11.1 specifically prohibits tenants from engaging in criminal conduct. Is that correct?
Yes.
Okay. Now, pursuant to paragraph 23.1B is a default of lease for a tenant to engage in a violation of the lease and or a violation of any criminal laws.
Yes.
So this is another basis for the property seeking possession of the property, correct?
Yes. Yes.
Okay. Ms. Cantu, I pulled up what's marked as Plaintiff's Exhibit 5. Do you recognize this document?
Yes, I do.
Is this a true and correct copy of the resident charges and payments ledger for Mr. Waeh there at Estancia Villas?
Yes.
Okay, and does this document indicate that no payments have been made on Mr. Waeh's account beginning September 1 of 2023?
Yes.
Okay.
No payments have been.
Okay. How much has Mr. Waeh actually deposited or paid to the property since he moved into the premises?
Let me just clarify before you answer that question, ma'am. If you know the answer from your memory without reference to this document, you can answer it. But since the document has not yet been admitted, I don't want you to testify from the document. You can offer it at this time if you wish, but
Your Honor, we offer Plaintiff's Exhibit 5.
Is there any legal objection to this document, Mr. Waeh?
Yes.
What is your legal objection?
My legal objection is it's inaccurate.
That's not a legal objection. That really, again,
Okay.
goes to the way you can cross-examine her on it and point out any inaccuracies, but that wouldn't prevent it from coming in. That might.
Absolutely.
Does that make sense? Okay.
It sure does.
All right. Then that objection's overruled. plaintiff's exhibit number 5 is admitted, but I'll just point out that Mr. Waeh has an opportunity to cross-examine and offer his own evidence in connection with this document. Go ahead.
Ms. Cantu, how much has Mr. Waeh paid the property?
I believe it's 720, but also with deposit, or 720.
I'm sorry, I didn't understand. Your audio broke up for me. Could you repeat your answer, please?
$720.
So Ms. Cantu, since the beginning of his tenancy on or about August 23 of 2023, Mr. Waeh has only paid $720 to the property. Is that correct?
That is correct.
Okay. Ms. Cantu, Mr. Waeh is still in possession of the property, right?
Yes.
Okay. Ms. Cantu, that's all the questions I have, Your Honor. I pass the witness.
All right, Mr. Waeh, now is your opportunity to ask Ms. Cantu questions that relate only to the issues in the case.
Yes.
And just as a reminder for us all, just question and answer. So this is not your opportunity to testify. You'll have that opportunity later. Just
Okay.
question and answer.
All right. So why then did you guys write amount claimed as of November 1st to be the exact amount that I needed? Because rent was paid for me.
I'm sorry. I don't understand what you mean by the amount that I needed. So can you
Yes,
just
I
clarify?
comprehend.
Go ahead.
Oh, yes, ma'am. So on the original petition, there is an amount claimed as of the date that you filed the petition. Why then is there a balance that doesn't reflect that?
If you're referring to the eviction petition, we will list the amount that is owed at that time of filing the eviction.
You're not understanding my question. And I'll show you the exhibit. The exhibit says the amount claimed as of that time, which you
Mr.
filed
Waeh.
November 1st. Amanda
Mr. Waeh?
Cantu. Yes,
Mr.
ma'am.
Waeh, what you're doing is offering a statement, which is your testimony, right? But we're not at that stage yet. No, you made a statement. You've got to ask her a question. So you could, for example, say on such and such a day, how much did I owe? And if that's a different number than that's on the document, then your follow-up question could be, well, why is that number different than what's on exhibit 2 or whatever, right?
Okay.
You can
On
break
November
it down
1st.
that way, but you
On
can't
November-
just sort of. Does that
On
make some
November
sense?
1st, Amanda Cantu, on November 1st, how much rent did I owe at the time you filed the petition?
On November 1st, your total balance was $4,426.36. That's including rent, utilities.
Okay, copy that. My next question is, why then would you put the amount of rent claimed as of this date of filing is $4,068.00 on a legal document at 5:30 p.m. 11/1.
Your Honor,
I think, let me just make sure I understand the question. I think what I'm asking, Mr. Waeh, I just want to clarify. The question you're asking is, if you owed $4,400 roughly, why did she only list less than that amount? Is that your question?
Exactly.
You owed more, but she only listed a little less than you actually
Yeah,
owed.
and I'm
You wanna
only
know-
asking
Well,
that.
hang on.
I'm only-
No, don't tell me why. Just trying to
sorry.
understand the question. I think
Yes,
what
ma'am.
he's asking you, just to clarify, because I was confused a little bit by the question myself. I think what he's asking you is, if he owed more, why'd you put less than what he owed on the documents? I think that's his question. Is that right, sir?
Correct. Yes, ma'am.
That's his question.
At the
If
time
you
of,
owed 4,400, why'd you only put 4,000? That's his question, basically.
yes, at the time of filing the eviction, we are only evicting for past due rent. We are not evicting for past due water, sewer, any additional fees, late fees. It is only for being in violation of non-payment of rent.
Wow.
So, Mr. Waeh, you really just have to ask her a question. You don't get to editorialize. Come on.
I'm sorry. I
That's
apologize.
all right. I know it's not always easy, but if you would, just ask her another question, please.
Why did you put you're not suing for any unpaid rent? Or if you were intending to evict me, why would you put there weren't any lease violations? Why would you put you weren't suing for any unpaid rent or any applicable attorney fees on this original petition? Why then did you do all those in that order?
Your Honor, I'm going to object to the question based on relevance. This is a de novo trial in a county court case.
Excuse me. I will sustain the objection. Mr. Waeh, they can decide as the plaintiff whether to sue you for everything they can under the sun or for only some of the things they can under the sun. They don't have to justify why they only picked one thing when they could have picked 20 things. So it's not really relevant. It's only relevant as to whether or not what they did file is true and accurate. And do they get to win their case based on what they did file, not what they didn't file. So I'll sustain the objection. Next question.
That is it for my questions regarding that witness, Amanda Cantu. And we'll get to the testimony. We'll talk.
Thank you, Mr. Waeh. Ms. Du Bois, any redirect?
No, Your Honor.
Thank you, Ms. Cantu. You may turn over the microphone to the next witness. Ms. Du Bois, you may call your next witness.
Your Honor, I would just like to briefly call myself for attorney's fees.
You'll raise your right hand. I'll swear you in. Do you solemnly swear or affirm under the penalty of perjury that the testimony you will give in this cause will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor, I feel is.
You may
Would
proceed.
be an additional sum of $5,000 in attorney's fees. Your Honor, I have provided to the court Plaintiff's Exhibit 6. This has been uploaded onto Box. This is a true and correct copy of my activities export with Rogers Law Firm showing the work that's been done on this case. Prior to trial today, Your Honor, I have spent 8.9 hours of time on the case, and that was for a total sum of $2,417. And we are just asking for additional sums through trial today for that $2,600. And I'd ask that Plaintiff's Exhibit 6 be offered.
Can you share your screen so that Mr. Waeh has a sense
Sure.
of what you're referring to when you refer to Plaintiff's Exhibit 6, just in case he hasn't seen it in the box folder? This is her activities report related to the work she's performed. Mr. Waeh, do you have any legal objection to Plaintiff's Exhibit number 6?
Legal objections. Let me see. Yeah, I really think that's inadmissible, seeing as the original petition. But if that's not a legal objection, then carry on.
I'll
Because-
overrule that objection because this is a trial de novo and they get to essentially have a new trial on their claims, and they've included a request for attorney's fees in that claim. So I'll overrule that objection and admit petitioner's exhibit number 6.
So when did we get to a de novo trial? Well,
When
I'll get
you
to my
appeal-
trial card.
When you appeal from the justice court decision,
Mhm.
when you go from JP court to county court,
Mhm.
in county court, you get a new trial. That's
Okay.
the way it works. Evictions, the justice of the peace court has what we call exclusive jurisdiction, which means every eviction has to start in JP court. Can't file it in any other kind of court, has to be filed in JP court.
Mhm.
From JP court, the justice court, any appeal for an eviction from that court then goes to the county court at law. And if there's an appeal from the county court at law, that goes to the third court of appeals. If it's in Travis County, goes to the intermediate court of appeals, from there to the Supreme Court. So that's the sequence of review that you get. Start in JP court, then you get to county court. When you go from JP court to county court, it's a new trial. When you go from county court to the next appellate court, you don't get a new trial unless they order one. You just get an appellate review at that stage. So that's the difference. All right. Anything further, Ms. Du Bois, or do you rest?
Plaintiff rests, Your Honor.
All right, Mr. Waeh, it's now your opportunity to call any witnesses or offer any documents into evidence, and you may call your first witness at this time.
Yeah, my first witness, I would like to call Jennifer Alvarado.
All right, Ms. Alvarado, if you would get closer to that microphone, please, and raise your right hand, I'll swear you in. Do you solemnly swear or affirm under the penalty of perjury that the testimony you will give in this cause will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
State your name for the record, please.
Jennifer Alvarado.
All right, Mr. Waeh, you may ask your first question. Go ahead.
The first question I have to ask is, why would you tell me your name was Amanda Cantu? They've been having me under the impression.
Mr. Waeh, just question, answer. Question, answer. When it's your turn to testify, you can tell me more. But right now, just question and answer.
I apologize.
No worries. Go ahead, Ms. Alvarado.
Your Honor, I'm going to object based on relevance. There's
Well,
no-
it might or might not be relevant given Ms. Cantu's statement that she hand delivered something to him. So it might be relevant. It might not be relevant. I can't tell yet. I will overrule the objection. You may answer the question if you can.
I have never stated my name is Amanda Cantu.
Next question.
No witness.
That's not a question. You have to ask her a question.
No, I was saying that was it for the witnesses. I
Oh,
was
you said no
just
witness. Oh, you mean you passed the witness? Okay. I don't think he has any other questions for Ms. Alvarado. Ms. Du Bois, do you?
No.
I just got to speak, apparently.
Okay. All right. Thank you, ma'am. You may step down and you all may mute your microphone. Okay. Mr. Waeh, you may call your next witness.
Okay, that's it for the witnesses. I apologize.
So you don't have any other witnesses that you want to call? Did you want to offer testimony yourself?
Absolutely.
Okay.
Absolutely.
Well, if you'll turn your video camera back on. There you
Oh,
go.
sorry. I didn't know it was on.
That's all right. It just went off for just a second there.
Okay.
If you'll raise your right hand, I'll swear you in.
All right.
Do you solemnly swear or affirm under the penalty of perjury that the testimony you will give in this cause will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
State your name for the record, please.
My name is Alan Waeh, representing myself pro se in this case.
And your last name is spelled W-E-A-H, correct?
Yes, ma'am.
All right, very good. Now, Mr. Waeh, let me just point out a couple things just as we get started. Because you're representing yourself and you're acting as your own lawyer, it would be a little silly for you to ask yourself a question and then answer it. That really wouldn't make any sense. So because of that, you'll be allowed to testify in what we call the narrative form, meaning you don't have to ask yourself a question and then answer it. You just get to give me the information. Okay. However, couple things to keep in mind. One, if Ms. Du Bois raises an objection, you'll know that because she's going to say objection. Or if I interrupt you, I need you to stop your testimony until I can deal with whatever reason I might have interrupted you or whatever reason Ms. Du Bois wants to raise her objection. So at that point, I need you to stop your testimony till we can deal with those interruptions, and then you can be allowed to proceed. Does that make sense?
Absolutely.
Right. One other thing, couple other things to remember. One is you tend to talk pretty fast, and
Sure do.
in order to, I know, and in order to be respectful to our court reporter who's trying to take down a clear record, I'd ask you to slow down a little bit so that she can get everything you're saying onto our record. Okay.
Gotcha.
Last thing is I need you to stay focused only on the issues that are before the court and not on things that I don't have jurisdiction to deal with or can't handle. So right now it's kind of simple what we're doing, but I want you to be able to tell me your story because I know you have a story to tell and I want to hear it, but I want you to do it. I want you to do it slowly enough that we can hear it. And don't forget to let me deal with these objections. The final thing I want to point out is that we've been going a while, and given the pace of everybody's speech pattern, I'm going to have to give Ms. Duet a break here shortly. So probably in about 15 minutes or so, if she can hang on that long. Looks like she can. All right, good. She's telling me she can go another 15 minutes. I'm going to break at about 9:15ish, and then we'll take about a 10-minute break, and then we'll come back and finish up whatever we haven't finished by then. But I've got to give her a rest at some point since we've been at it for over an hour. Okay. All right, Mr. Waeh, you may proceed now with your direct examination.
Yeah.
And so following that, Mr. Boyd will have an opportunity to ask you some questions on cross-examination. But for now, we'll start with your direct examination, and you may proceed.
Yeah, I wanted to start with when I moved in. The first thing that happened was I moved in and signed the lease and everything like that. I checked out building 4. Long story short, they ended up moving me to building 6. It's on the clubhouse camera. When I met Amanda, she gave me her card with her name on it, and it said Amanda Cantu. That's documented. I've asked for subpoenas. I've asked for 4 subpoenas in order to get the information in this case, because that's actually relevant now. Because Amanda Cantu said she delivered a notice to vacate. She hand-delivered it to me, which technically was Jennifer Alvarado. If that makes any sense. Okay, so
I understand what you're saying. Keep going.
Yeah, so basically they evicted me. I had moved into the apartment, I think August 21st. September shows up, UDR, like some sort of billion-dollar corporation, comes in and buys out this place. They upgrade the locks to a bunch of smart locks. Long story short, I'm on camera right now. Every aspect of my life is on camera. Irrespective of that, you could just look at the original petition. The original petition itself does not give any merit to even have the trial. Because 1, they had all the money at that point in time, signed and date stamped, and then they weren't suing for anything. I hadn't violated the lease or I hadn't done anything. There was 0 cause to even evict me. The only outlet that I would have is to appeal the eviction. To make any sense, if I wanted to stay there, I would have to appeal the eviction. So as of November 1st.
But may I just ask a clarifying question? The testimony in the record so far from the plaintiff is that you were to pay $1,356 per month, and that to date you've only paid $720. So when you say you didn't owe any money, I'm confused by that. Could you explain? Could you explain to me the dollar amounts? And if you could, we're going to take a break here in a minute. If you don't mind waiting to enjoy your breakfast or snack or whatever you're eating, if you could wait and do that until we take our break, that would be really, really helpful to me. So I need you to clarify. You're saying you didn't owe them any money. They're saying you never paid even a full month's rent. Could you just help me understand that?
So what's the amount? 1,300 and what? 56?
I believe the testimony in the record is $1,356 per month.
So that's September, October, November, right? Okay, so that 1,356 multiplied by September, October, November equates to $4,068. If you go back to the original petition, this is what I'm trying to argue here. They literally have the document signed by an authorized representative stating the amount of rent claimed as of this date of filing is $4,068.00. My thing that I'm saying is essentially there was no cause, there was no merit to evict me because they had rent. They said they claimed it on my behalf. They're not suing for anything. I haven't broken any violations or any lease. It is literally the reason why we're here right now. There's no other option for me if I wanted to keep my location other than to appeal.
Here's what I'm asking though, Mr. Waeh, for clarification. They're telling me that you owe $1,356 a month.
Yes.
And that you have only paid $720.
No, incorrect.
Okay, that's what I'm asking you to tell me. So they're saying they're saying you owe $1,356 every month. You owed it in September. You owed it in October. You owed it in November. And they're
Yeah, so
telling
check
me
this
in
out.
all that, excuse me, they're telling me
Sorry.
in all that time, you've only paid 720. So I need you to
Nope.
help me understand the
No.
payments that you've made. Can you talk to me
Gotcha.
about that?
Okay, so on November 1st, at 5:25 p.m., there was $4,068 paid on my behalf to Estancia Villas, period. In addition to that, that's not even accurate because my deposit in conjunction with the August month adds an additional $720. So in reality, it's
So
actually,
hold on. When you say that a sum of $4,068 was paid on your behalf, can you tell me more
Yes.
about that? Who paid it? Where's the check? Tell me more about the payment and so forth.
the managers paid it for me because they've been monitoring me. They've been putting me on camera. They've been putting me on camera and circulating my information. There's a bunch of nonsense going on here. And that's
So
what the
what-
payment was for.
So hang on a second. When you say that the managers paid it for you, tell me more
Yes.
about that. Who
Yes.
paid it? How did they pay it?
Jennifer Alvarado. It doesn't matter. It was electronically paid for me. It was taken care of on my behalf for me. They have it documented here, time and date stamp.
Why would the managers pay
Thank
your
you.
rent for you?
Thank you. Because they have some organization going on here where they're trying to demasculinize men. And as soon as I step foot in here, ever since then, it's been a whole campaign to separate my genitals from me. It sounds ludicrous. But there's exact information, there's visual communications, there's emotional continuance. You guys are treating this trial like it's just some sort of eviction, copy, paste, cut, paste, and that's it. There's so much information in here.
Okay, so wait, hang on.
That's why it was paid. That's why it was paid for me.
Okay, so hold on. So let me just back up because I want to do this in sort of pieces that I can understand and we get a clear
For
record.
sure.
If I understand what you're telling me that on November 1 at 5:25 in the afternoon on that day, Ms. Alvarado, on behalf of Estancia or on behalf of herself?
Nope, I'm saying prior to that date, right? It doesn't matter if she says she's going to pay it for me, it doesn't matter. Prior to that date, it was paid. It was paid on my behalf for that reason exclusively. Me being on camera inside my location.
Okay, so let me
I have
just be
zero
clear.
privacy.
Do you know in what way money changed hands from Ms. Alvarado or anybody else on your behalf to pay your rent? Can you tell me more about how that payment was made? Tell me what you know about that, other than what somebody may have told you. I don't want you to tell me what they told you so much as I want you to tell me what you know happened, if you do.
Management paid my rent prior to that date. It's on the legal document right here.
How do you know they paid your rent?
Because they told me that they would. I've been on camera. Okay. They've been circulating my information on social media, laughing at me, putting me.
Who told you that they paid it? Who told you that?
The manager. Jennifer Alvarado told me that she paid it. The manager.
Okay. So let me just be clear.
Prior to that date right there. It was paid on my behalf.
Okay, let me be clear. Let me be clear. Your testimony today is that on or before November 1st, $4,068, the $4,068 that you owe in rent to that date was paid on your behalf by the manager of Estancia Villas, Ms. Alvarado.
UDR essentially, but through her as an authorized agent. UDR essentially, but through her as an authorized agent.
All right. So they paid your testimony is that Ms. Alvarado on behalf of her employer paid your rent for you.
They wanted me to leave is why they put that number down there. So they paid the rent to have me leave. That's what that was about.
Okay. All right.
And the reason why, and I'm still in the testimony if I'm okay to continue.
Yes, you may continue.
Okay. The reason why that number is down there is because I've been monitored. They've installed smart locks out here and they have access to my codes. On the inside of this door, I have permission, have the ability to lock the door and prevent anybody from coming inside here. When I exit and I go to the outside of the door, it's an electronic code. When I leave, these guys have me on GPS. I come back inside myself all over the place. They're setting up spy cameras and all kinds of nonsense and circulating my information. Estancia Villas in general. And when I mentioned that thing about them trying to separate my genitals from me, not physically, but they've been doing all kinds of psychological tactics to do so, like messing around. And I have the visual communications. First and foremost, let me go ahead and reiterate that this was supposed to be a jury trial. The fact that you guys are trying to consolidate the trial, they've been doing so many things to just shut me up, put me in jail. I literally started submitting exhibits to the case. As soon as I submit an exhibit to the case, here comes an interception from Travis County Sheriff's Office and Travis County Civil Division as if I did anything wrong. We're literally in an ongoing dispute and these guys come in and intercept. This is a massive case I was trying to exhibit here. The first thing I gotta say is, just on the merits of the original petition, like they do not have cause to evict me. Like I said, it was paid on my behalf. That's how much they collected. It was the exact amount. And now look, they don't even have a lease violation. They don't have a holdover. They don't have anything for applicable attorney fees. And it's because I know what I know. The reason for the countersuit was because I wanted to relay what I know. You guys are trying to separate it and do all kinds of stuff. The way that they moved about this was absolutely, they shouldn't even process this case. The first thing they should have said was, hey, this dude didn't even do it. What are you trying to evict this dude for? And if I would have co-signed it, then they would have permission, but I didn't. So here
Let me stop you there to ask another clarifying question. Since you take the position that your rent has been paid through November, right? All right. So can you tell me what amount of sums have been paid by you for the months December 2023, January 2024, and February 2024? Have you made any rent payments as required under the lease agreement for the months of December 2023, January 2024, or February 2024?
No. And the reason why, if I'm still inside my testimony, is because with them only suing for the right of possession, and this was told to me by the JP courts, I have documentation of my statement of inability to pay. It literally says, so I've been able to not pay rent. They didn't sue me for anything. That literally prompted me not, they just took my statement of inability to pay. So essentially, I don't owe anything to the JP court, and I don't owe anything going forward until we come to trial.
Let me stop you there.
And let me find the document. I'm sorry.
My question was simply whether or not you paid rent. Your position is that your rent was paid through November, that someone paid it on your behalf. That's what you told me. And if that's true, then the question is, on December 1, did you pay rent? Did you pay rent to them?
Okay. Well, on December 1, I did not give any money to JP court.
Hold on. Mr. Waeh, stop. I'm still trying to get to the sort of clarifying question I'm trying to ask. So if I understand correctly, you think your rent was paid through November. And so I understand that. If that's true, then the next point in time in which you would have owed rent would have been December of 2023. And if I understand your testimony, you did not make a payment of rent in December of 2023. Is that right?
No, I did not. Can I continue with the testimony?
Hang on. I'm trying to clarify what you said about the payments.
Yes, ma'am.
Okay. So you didn't pay in December, you didn't pay in January, you didn't pay in February, correct?
It was paid. Right? I had a zero balance in in December, January, February, and anything beyond that, I have a zero balance. So technically,
okay, wait, stop. I'm asking about things you actually did, not your legal theories. That's why I'm trying to back up and clarify. You're giving me your sort of legal theory about why you owed or didn't owe something. That's not my question.
I got you.
I'm asking a very simple factual question. Did you make a payment of $1,356 to Estancia Villas in December 2023? Yes or no?
I paid $0 to Estancia Villas in December 2023.
Okay.
As far as December?
No. Just getting some facts here. In January 2024, did you make a payment to Estancia Villas in the amount of $1,356? Yes or no?
No.
Okay. And in February 2024, did you make a payment of $1,356 to Estancia Villas? Yes or no?
No.
Okay. Now, next question. The affidavit of inability to pay. That is a document that you filed in the court file, correct?
Yes.
Okay. I just wanted to make sure factually I understood what you were saying. Now you can continue with your testimony.
Sorry. Yes. So basically with that statement of inability to pay, they had a cash surety balance of like $277. And this is why I'm actually suing JP3 too, because they had a cash surety of $2,700, which basically I substituted with that statement of inability to pay. And it is co-opt with the fact that they only sued for right of possession prompted me to only owe $0.00 going forward, confirmed by JP court. And I have the documents to prove it. So technically, the original petition, I didn't owe any money, and then Estancia Villa accepted it. They co-signed it. They had the opportunity to say no. They accepted it. They signed off on it. I have that too. Now going forward into the new trial here, my stuff was accepted as far as me not being able to pay. So we have the initial petition, irrelevant. Moving forward to the new trial, I'm not paying for December, January, February, or anything beyond because they only sued for right of possession. Here we are in court to argue about the merits of the case. That's why prior to this moment in time, they did not get any money from me between the points of right now and December 1st.
This is really helpful. I think there may be some
Let me find that document. Sorry.
Yeah, I think there may be some misunderstanding of what things mean that are filed. For example, the affidavit of inability to pay does not mean you don't have to pay your rent, for example. No. That's not what it means.
That's not what I'm saying.
But I understand. I think I understand a little better about sort of how we got where we are, and this has been really helpful. I'm going to let you go ahead and finish up with your testimony because now I got a better sense, and we'll get a little farther, and then we're going to have to take a break to give the court reporter a rest.
Oh, for sure.
Go ahead.
Yes, ma'am. So, that statement of inability, and then so on top of that, I essentially countersued because I was then aware of the nonsense that was going on. It's so disgusting. And if you guys, or you don't have the power to process that case, it really doesn't matter. These guys are talking about an eviction appeal as though like this isn't the biggest news. This is very big. So I just want you guys to know, independent of that, like there will be suits. But if we can escalate to a higher...
Don't stop. I got to keep you focused on this case, these merits. Okay. It's the same thing I told Mr. Boyd before she told me she had pleadings about other things. Same thing. Just focus on what we're here about today. You have a right to
let me just reiterate everything then. First, on a video in the clubhouse, when I first arrived, Amanda Cantu, or who I thought is technically Jennifer Alvarado right now, handed me a card. And on that card, it said Amanda Cantu. From that point when I initially got here till now, or just about a week ago when she told me, well, I'm actually Jennifer. Like I was under the impression, and I would call to and can I talk to Jennifer, then they would transfer her.
Your Honor, I'm going to object based on relevance. I have no idea how this has anything to do with the claim.
Because of the notice to vacate. Because of the notice to vacate. Who served it to me?
Mr. Waeh?
Sorry.
I'm going to sustain her objection because the notice to vacate, which is in evidence, doesn't really matter who handed it to you. It matters that you received it. So
Okay.
she's correct.
And
We can move on from there. Go ahead.
and it's also relevant because imagine
No,
having
we're
a
not going to
manager.
argue that. No, stop.
Yeah,
We're going to move on
okay.
past that. Go ahead.
Okay, 10-4. So they said incorrect names, whatever. I was under that impression. Now back to the original petition. Again, they have the amount. Literally, it says the amount claimed. It
Your
was
Honor,
inaccurate.
I'm gonna object. I'm gonna object again based on
Okay,
relevance.
stop,
to the de novo trial.
stop.
I'm just trying to summarize.
No, yeah. So I'm going to overrule Ms. Du Bois' objection, but I'm going to ask you not to reiterate because that's really just repetitious.
Okay.
Everybody's been listening all morning, certainly me. We
Perfect.
have a record.
This is
I don't
as
need
I'm
you to
clear to you guys.
summarize. I don't need you to summarize or reiterate. I need you to tell me something you've not already told me.
Okay. So you've already gotten the portion of me not owing rent because of the
You don't
basically
need to
told by the-
summarize. You don't need to summarize.
Okay.
Keep going. If there's anything else, keep going.
I'm just thinking.
No, take your time. I'll tell you what, let's take
Yeah.
our break round. That way you can give time. You have some
Get some
time to
juices
reflect.
flowing, right?
Yeah, well, organize your thoughts, I was thinking.
Yes, ma'am.
All right, let's give our court reporter and everybody else a comfort break. It's 9:25 by my watch. Let's take 10 minutes and we'll resume at 9:35.
Judge,
Perfect.
it's 11:25, Judge. Not.
I mean, sorry. 11:25, we'll resume at 11:30. I'm looking.
What the heck? That was so interesting. Bitch lying and I move and I fucking move. Bitch, you got cancer. Die. Stupid ass. You sitting there lying, you know, bitch, you told me your name was Amanda. Tell me how much of a fucking lie that is. You're under your fucking original petition, you're lying. All kinds of shit. The statement of inability to pay, you changed this shit. Stupid. Let me go. I think it's events prior. Exhibits, events prior. There we go. What a fucking idiot. You can tell by her body language too. Her body language, she's just looking all over the place. And I can't believe I gotta say this. I'm such a liar. I'm like, what the fuck? And I'm gonna appeal that shit. Fuck with me. Stupid ass. That shit's annoying because I can't. That shit's really annoying. And I move, and you're trying to make me look like a bad person, but I'm like, what the fuck? Yeah, and I'm getting back to my trial, bro. And I fucking got a job and got arrested. That's what the next part you need to talk about. Yes, that's the next thing you need to talk about. He said, yeah, so I basically got arrested and they followed suit and decided to do all this nonsense. So all my shit's on file. You can't reset the trial, bitch. He said the shit literally says that you fucking paid. Perfect. You got the documents. I didn't share that shit. I didn't even share that shit. You put my shit over there and Travis County intercepted, bro. I'm glad I said that shit, bro. Fuck out of here. Stupid ass. You're doing all this nasty shit, all this weird shit. That's why the fuck it was paid for me, because I know this information. Stupid ass. Did you not look at my documents online? Just trying to lie and trying to make me seem like I'm bad. And this dude's coming over here and he's doing this and he's getting arrested. Did you look at the documents, you fucking idiot? Yeah, bro. I haven't even talked about the simulation yet. Yeah, they said she moved. Thank God. You're the one raping your kids. And they're just making me say it. And I've been doing it. I'm telling you, they're fucking putting fingers in my shit. And you know it's true. Circulating my fucking information. What the fuck do you have to say about that? I'm gonna peel the fuck out of that watch. Okay, so you need to talk about the jury demand, and then you need to talk about you need to show your documents, bro. Whew, let's go. I'm not even done. I'm not even done on my statement, bro. You say here goes, share my screen. Here goes the documents. So people are looking at because they accepted my statement, they deleted the statement, so I wouldn't even pay you to did. We'll fucking count. until fucking trial. That's what they told him. And then on top of that, then asked for so what's it called, trial, and they just denied it. Woo! You guys want a few things here. That just didn't even have a fucking answer. Why just put that on the fucking petition? Stupid. Try to get rid of it. Let's go back in here. Anybody likes it? Bitch, you the same shit. I'm pretty sure everybody likes it right now. I don't care if they don't. Stupid ass. You mad at your children are getting fucked and doing all kinds of nasty shit, and you wouldn't be mad that I fucking know about it. And I'm trying to fucking figure out how to tell people about it. And you're asking me everything to fucking lie and see. Ooh, I can't wait. I cannot wait. I cannot wait. Go back in. And you're talking so fast, bitch. Fucking process faster. Like I said, lady does have to jot down everything I'm saying. But I keep getting interrupted. He said, I have a motion of continuance. He said, I'm not having a fair trial. I have multiple documents on how to have my continuance on none of this shit. You're not looking at demand trial, you're not looking at nothing. You know what I'm saying? There's been a demand on there. Get back to your demand, bro. Your demand for a jury, take notes. Demand for a jury trial. Tenant's notice of appeal for a rent payment. Perfect. That's the next one you need to show right there. Yep. And then your fucking notice for rent. For your demand. Your jury trial for demand. Yeah. Yeah. I can understand them and now put a fucking demand on there. And then don't let that slide, bro. Don't let that shit slide. Don't let the demand slide. You know what I'm saying? And don't let the fucking well, I'm not paying rent. Like I didn't pay rent because we had everything. You know what I'm saying? And then after I didn't pay rent, it's because I didn't owe it. You know what I'm saying? So then here we are for trial. I asked for a jury trial. Why the fuck are we here? I've been asked for a demand for a jury trial. I'm not playing no games. And I'm gonna show them too. And then don't forget to tell how Aaron's lying and doing a bunch of stuff that's literally against the fucking. Ooh, and I'm gonna tell them too the date. The date. Yes, thank you. Date of. Perfect. That bitch gonna try and make me look bad. Well, you try to make us look bad, bitch. Ain't nobody care about you. You're ugly as fuck anyways. And hold on. Don't even do it, bro. Body language is so, bro, you can read niggas. That bitch doesn't even want to say that shit. That's so weird. Why are you saying it? What if they actually are like control? I just know you bitches is eating dicks. Why are you saying it? What if they actually are like controlled? I just know you. That shit pissed me off just now, bro. I had to raise my voice because what the fuck is wrong with you? Damn, I ain't gonna lie, bro. The judge is actually impartial.
This court is back in session.
Oh shit. Oh. There's no way.
All right, thank you for that. I know the court reporter appreciates the break, and everybody else could have time to get comfortable. So good. Mr. Waeh, let's continue then with your testimony so that you have time to wrap up with all of your.
Yes. Can I share my screen?
Yes.
First, nice. All right, so share screen. So how do you start broadcast? Okay.
If you just hit that, yeah, there you go.
If I say stop share, will that stop everything?
It will stop your share. They won't take
Okay.
you out of the Zoom room. It just stop your share.
Yes, ma'am. So I just want to point out that during this whole thing with the appeal after the decision from the judge, I had 5 days to appeal, and I basically submitted my statement of inability to pay. But last minute, they tried to change it. If I zoom in over here, they asked for 1,356. And I basically clarified, I had to call. I literally left work. I was about to go pay this money and everything like that. And I had to call to verify because they told me initially, since they sued for right of possession only, I wouldn't have to pay anything. Called, clarified, got
Your
that.
Honor, I'm gonna object based on hearsay.
Well, I'm about to show you. You should have waited. You should have waited 30 seconds.
No, Mr. Waeh, she has a right to object when she wants to object, as do you. It's okay. She doesn't have to wait. She can object. I'm going to sustain her objection because whoever told you is a hearsay statement. So that's a legitimate objection. I will sustain it. Please don't tell me what anybody else said. The exception, though, one of them to that rule is you can tell me what the representatives from Estancia may have told you, but not some other person you've not identified. So this is sustained for that reason. Let's move on and just give me the facts. I'm right. Right. This part of the process, the evidence phase, is where I get the facts. And then in closing argument, you all can argue the law to me and then I'll make a decision.
Okay.
But right now, I just need the facts. What happened? What'd you do?
Well, it's a fact that after I corrected them, they went ahead and changed it back. And I didn't owe anything. And then after that point, they actually signed off on this Estancia Villas right there. After they corrected it for not the 1,300.
Well, hang on. If you'll go to that, I see that document, but you scrolled pretty fast. I couldn't read the other two. So I see this one. And just for the record, stop, hold on. Go back down a little bit. Just for the record, the document that Mr. Waeh is showing us on the screen right now. Can you scroll down just a little bit so I can
Yes,
better?
ma'am.
That's good. He's showing us on his share screen, tenant's notice to appeal for non-payment of rent. Dated, it has a date of November 21, 2023, and then signed by Mr. Waeh. Go scroll down and let me just note the next one. The next document that he's showing on his screen is entitled Notice of Appeal with Statement of Inability to Afford Appeal Bond / Surety Bond, signed by Mr. Waeh, also, or has his, what appears to be his signature, and dated also on, looks like November. I can't tell if that's the 27th of November. Is that what it says?
Yeah, let me clarify for you. So on the 16th,
that's better. Hold on, just let me note what they are.
Yep.
November 27, 2023. Thank you for blowing that up. Scroll down. I'm gonna tell her, note the third one. The third document is entitled, it at the top says confidential is kind of the title of the document, if you will. Dated November 21, 2023. It is on letterhead of Judge Sylvia Holmes, Justice of the Peace, Precinct 3, Travis County, in this cause number. And it is a document also signed, apparently by Mr. Waeh, with the date of November 27, 2023, which further says request to appeal by statement of inability to afford payment of court cost or an appeal bond in justice court. Are there other documents on your share screen?
Your Honor, may I clarify something for the court?
I right now, I just want to note for the record what he's showing us, and then we can talk about what it is. But right now, I just trying to clarify, is there anything else that you're showing on your screen, sir?
Yes, that's it. I just wanted to show that one. And then the next thing that I want to get to in the
Hold
testimony.
on, because Mr. Boyd has a question about those. I just wanted to note what he was showing us, because the appellate record won't capture that since they're not being offered or admitted into evidence. He's just showing it to us. Mr. Boyd, you have a question about what he has shared?
Your Honor, on that third page, the document that titled confidential, that's actually Amanda Cantu's signature. It is a non-contesting the statement of inability to pay. So
I see. Thank you for that clarification. It was hard to read that signature, and I couldn't tell it from the others, which is why I said it appears, because I'm not verifying anybody's signature. But thank you for that clarification. All right, Mr. Waeh, you may proceed with your testimony.
So now back to the jury demand. As I was filing pro
No,
se,
no. We're not going back to that because I've already decided that we're going to proceed and I can't change what Judge Wong has already done. That
Well-
is something that you can appeal to the Court of Appeals. You can certainly do that, but that's not the subject of our hearing today. So we're going to move
it's
past
relevant.
that.
So I can't mention in my testimony why I request. Basically, what you're saying right now, and if I can continue for 30 seconds, please. What you're telling me right now is that based on the fact that you don't have information or you're going off of their information, I can't tell you my side of the story, is what you're
No,
saying.
that's not what I'm saying. That's not
Okay,
what I'm
please
saying.
clarify.
Let me say what I'm saying.
Mhm.
What I'm telling you is that the issue of whether or not you are entitled to a jury has already been decided by a judge. I do not work as, I'm not an appellate court judge. I'm a trial court judge. And so my decision gets appealed to the Court of Appeals. Judge Wong's decision gets appealed to the Court of Appeals. We're not the boss of each other, so to speak, right? He makes his rulings, and if you don't like his ruling, you got to go to the Court of Appeals. I'll make a ruling. If you don't like my ruling, you can go to the Court of Appeals, but he can't overrule me and I can't overrule him for things that have already been decided. Does that make sense? That doesn't mean that people can't ask they be reconsidered, or that certainly is something that could happen.
I hear
But
you.
Yeah, so what I'm saying is I'm not reconsidering his ruling. I'm saying that right now, the law of the case is that he has decided that your jury demand was not timely filed. I'm not changing his ruling about that, but that is a ruling that if you don't agree with, you have a right to appeal to the Court of Appeals. Just like when we're finished today and I make a ruling, if either side does not like that ruling, either side has a right to go to the Court of Appeals. Does that make sense?
Yes, ma'am.
Okay, all right. Go ahead.
I would just like to, I have to mention that because it's relevant to the case. You don't need to overrule, but I do need to tell the story as this is being recorded.
Okay,
So
go
I
ahead.
feel like it's okay. I just need 2 minutes uninterrupted.
Well, I
As a
can't
pro
promise
se?
that, but I will let you go.
Yeah. Aaron
Go ahead.
cannot furnish, the plaintiff cannot furnish a notice of that set trial. They didn't notify
I'm sorry, I didn't hear you.
Yes,
The plaintiff cannot. Hold
the
on,
counter
hold on.
plaintiff.
Stop. Let me tell you what I heard so you'll know where to start. Here's the last thing I heard was the plaintiff cannot provide a notice.
The plaintiff did not provide and still cannot furnish a notice of that trial date on January 18th, 2024. They never notified me. Now,
Okay.
let me tell you why they never notified me. On January 5th, I went to jail. On January 3rd, I had sent over evidence in this case to build my case. 2-3 days later, they processed a warrant, intercepted an ongoing case as I was trying to prove it, and just literally took me to jail. I'm working like a $160,000 job if she wants to talk about character. I get off on a Friday, and then boom. Saturday, Sunday, Monday, I get out. As soon as I get out, Aaron had 0 documents inputted into the system for any discovery of anything. I get out Monday night. It's like 11 or 12 o'clock in the morning. She starts sending me documents. The next thing is like, there's a trial set. And here you go. There was never any notice at all. I get out January 9th and they have court set January 18th. Now, January 11th, I had already set my, demand for jury. I had did it through the e-file system because they switched it from pro se and I could just file email and then they switched it. So I get out of jail, go in January 5th and get out January 11th. Prior to January 11th, they never had any trial date in there. There was never any information, never any notice or anything. So I get out immediately, notice a motion of continuance. I get out immediately, jury trial. I get out and I had already had that jury trial on file as far as emailing it. So that's literally the reason why we motioned to recuse Judge Todd Wong, because I had stuff on file and they were just ignoring it. They're bypassing it. I literally have Aaron on the record. I have the email right here of her saying that the responded email that I've been sending documents to filed in East, or she never seen it. Before they even set that January 18th trial, I had called Marilyn, her representative in her office, to let them know, hey, there is a demand on file. And then even prior to that,
Your Honor,
I'm not done.
Hang on, Mr. Waeh. Mr. Waeh, I tried to give you some leeway here, but I think I need to get you to focus on the facts that relate to the claims in the case that I am going to decide. I'm not going to decide this issue about the jury trial. That's not going to be.
So we can just appeal that then, right?
That's what I was trying to say
Yeah, all right,
earlier.
forget about it. I'll just appeal it because you guys aren't hearing what I'm saying. I just want this to be
Well,
recorded
it's
on
not
file.
that I'm. It's not
Yeah,
that
I just want it to be recorded
certainly-
on file. When they, sorry.
It's not that I'm not interested in what you have to say in the position you're taking. I am interested, but I am not going to overrule Judge Wong's decision. He's made it, it's done. And if you are not satisfied with that decision, your appeal to the Third Court of Appeals is the place in which you would deal with that issue.
Oh, yeah. All right, we'll just do it there.
So my point for today is just to focus on the issues that are before the court today, which are essentially a brand new trial on the eviction with the claims that the plaintiff has brought for non-payment of rent, as well as attorney's fees and other costs, right? That's all I'm here on with regard to the plaintiff's claims. Then your claims, the ones that I have jurisdiction over, which we'll sort out in a minute once I hear some evidence, right? And that's why I'm saying that at this point, we're just in the evidence phase. This is where I get facts, not argument, not legal discussion, just facts. What happened? Who did what? Who paid what? Who said what? Like, who did something? Those are the facts that I'm listening for, so that then after I hear your closing arguments where you will apply fact to law, then I will make a decision. Right? So give me the facts. What happened? Why shouldn't you be evicted? What did you pay? What didn't you pay? When did you pay it? That sort of thing. Make sense?
Okay. So I shouldn't be evicted because you don't want me to re-narrate this information, but the reason is the original petition. Past that, it's the next thing I just showed you, the document where I didn't need to pay anything to update until we get to trial here. Now they reset the trial. And to be honest with you, the way that you guys reset the trial, I'm not with it. And let me elaborate on that. One,
No. The trial was set. The trial was noticed. The trial was assigned to me. We're in the trial.
It's irrelevant. It's irrelevant. I hear you.
No, it's not. It's not that it's irrelevant. It's that it's not appropriate for now. That is something that you can complain about if you want to on appeal, but not for today. That's all I'm saying.
Well, no, I hear you. All I'm using
I'm not saying it's not relevant. I'm saying
Yeah,
it's not
I hear you.
appropriate because it's beyond the scope of what we're doing today.
I
That's
hear
all I'm
you.
saying.
All
Okay.
I'm saying is, you guys, and I'm looking up the thing from Angela. It's literally a hearing, quote unquote, document. I could share my screen. She told me it's a hearing. So what I'm trying to get at by referencing the demand trial is that this is inappropriate right now. To have a trial when I'm not prepared for it because I've had so many documents, and this is why he's being recused right now. I know it's irrelevant, but I need to mention it since we're on air and we're going in. This is not an appropriate trial because it was designed to be from a jury. Is what I'm
I
saying.
understand that. I understand
past
that.
that-
We're not going to deal with that today because that is the subject of something you're going to do on appeal. So for one more time, I'm going to ask you, please, to stick to just what is relevant for the purposes of our time together today, and that is the eviction issues. Did you pay rent? Did you not pay rent? And so forth. Now, in service of that, let me ask another clarifying question.
And there was a motion to transfer too. Sorry.
When you paid or filed, I should say, when you filed the affidavit indicating that you did not have the money to pay the appeal bond or the surety bond, did you understand that document to mean that you did not have to pay your rent also?
Ma'am, can I share my screen?
Yeah, you certainly can. But first answer my question.
Oh, am I supposed to-
Did you understand that document to mean that you did not have to pay your rent?
Which document?
Let me start over my question. Listen to my question. When you filed the affidavit that indicated that you could not afford to pay the appeal bond or the surety bond, when you signed that document and filed it, did you also think that document meant you did not have to file or pay your rent? Is that what you thought? That's my
not
question.
what I thought. That's not what I
Okay.
thought. The document said that I did not need to. It's not to estancia villas until the case is processed. It's either to the JP court or it's either to the civil court.
I don't
It
think you
is-
understand my question. Let me try again. And maybe you did understand it and maybe I got my answer, but let me clarify. I just want to clarify. When you filed the affidavit indicating that you could not afford to pay the appeal bond or the surety bond, when you filed that document, were you under the impression that that document relieved you of your obligation to pay your rent?
No.
Okay. All right. That's my question. You've answered it. Let's move on. Next part of your testimony related to the facts of the case, not the jury trial demand and all that. I just want to know about the facts of the eviction case. You may
Ma'am.
proceed with your testimony.
Am I on screen share right now?
Yes.
Okay. So stop screen share. Let's go to this. What does it say right here?
What I see on the screen is some email.
From Angela?
It related to a hearing confirmation, yes. But again, Mr. Waeh, that has to do with the procedural issues related to your request for hearing or trial or juries and so forth, which is not what I'm entertaining today. That is going
hear
to
you,
be,
but look
if you
below
want to talk about it, the subject of your appeal, should you decide to appeal once the decision has been made, not the subject of what we're doing today. And so I'm going to rule that that's not relevant. We're proceeding and we're in the middle of the trial. So I want to know
Ma'am,
about the
can I
facts
read
of the case. I want to know about the facts of the case. I want to know about your time at estancia, your rent, your claims against the plaintiff. Tell me about those facts, not about setting matters for a hearing. Okay?
No. Listen, ma'am, look, it literally, can I read this out loud to you, please?
No, you don't need to read it to me because I can read and I'm looking at the document and I've
It
seen
says
it.
as
I
well
understood it.
as the plaintiff notice of rent default for motion to transfer. There's a motion to transfer the case. Please
I
stop acting like
understand that. I understand
it
that.
literally says it right there. It's not just the merits. There's so much.
Mr. Waeh,
Okay,
Mr. Waeh.
Look, there's another one. There's another one. Here, check this out.
Hold on. Are you telling me that you want me to entertain a motion to transfer today? You have yet to say that, but if I'm
Ma'am,
now understanding you
You
to
tried
say
to shut
that,
me
then
down
stop.
consecutively
No,
and consecutively and consecutively.
Stop. I will add to our agenda a motion to transfer. Now, let me point out that when I was setting out the agenda earlier this morning, and I said, there are the 4 things we're going to talk about today, you did not mention there was also this motion to transfer. Had you done so, I would have been happy to add it to our agenda. I will add it now. So I'm going to add number 5 to our list of things to do today is your motion to transfer.
Your Honor.
Hold on. It's a little late in the game for us to do it, but we will come back to that in a minute. Right now, we are in the middle of your direct examination. Ms. Du Bois is entitled to a cross-examination. I need you to finish her direct examination so we can get to her cross-examination and to any other evidence you have to submit so that we can complete the evidence phase of our trial. So I will add motion to transfer to the document, which, as you point out, includes in the notice the merits of the trial to be discussed today, which is what we're doing, along with all those other things that we've added to our agenda. Now, move on, if you would please, to the next fact to tell me about your case.
I would like to be 100% respectful with you guys, but I think you're overlooking a lot of these facts. The first thing I want to mention, if I can just get 1 minute to go off, the first thing I want to mention is that you guys were already aware that there was a motion to transfer. Why was that not on the case? I'm not even done with that. All of my documents have been on file. Nobody looked at any of my documents prior to this. I'm trying to tell you about the demand for the jury.
First of all, that is not a correct statement because I did look at your documents before the trial. So I would appreciate you not assuming things about me. I'm not assuming anything about you, and I don't want you to assume anything about me. I appreciate that you have your opinion about these things. I respect that, but I need you to respect my ruling. Here is my ruling. We are in the middle of a trial on the merits. We are hearing at the moment your direct testimony, which is about the facts that relate to what happened in the case. So I need you to focus your attention and your testimony on what happened. Who did what? What did you pay? What didn't you pay? What did they do? What didn't they do?
I hear you.
And when you're done with your testimony, then I'm going to hear argument, at which point you can tell me these other things that aren't testimony. But in the middle of your examination, I just need to hear the facts. Okay? Related to the underlying litigation, related to your eviction. That's it. And then when we're done with that part of the case, I'm happy to hear these other things.
Okay, thank you for clarifying that. Thank you for clarifying. So pertaining to the case, there is the original petition, and then beyond that, there is the surety that I just showed you. And my impression is that I'm not supposed to pay until we're in trial. Now, as far as everything else, I'm gonna wait to relay that to you. But as far as that goes, that's it.
Let me clarify. When you say I'm not supposed to pay, that's what I was getting to earlier. What is it? What is it that you think that affidavit of inability to pay absolves you of the responsibility to pay?
Thank you. It absolves.
What do you think that you don't have to pay?
Since they sued me for right of possession only, that 1,356 was actually supposed to go to the JP courts on a monthly basis while we're going to court, is what I'm saying, right?
Okay.
To the JP court is what I'm, not to the County Villas, but to the JP courts. What they done after I had to speak with them is they corrected that document, right? Which actually let me go with $0.00 up till now. So what I'm trying to, what my ultimate argument is, the original petition, as if I didn't do anything wrong on it, if you look and you read the original petition in conjunction with the document of appeal and the surety. Like, I'm not paying to the JP court because they sued for right of possession only. And I'm also not paying to the Travis County court because they sued for right of possession only. Here we are on, what is this date? February 29th. And we're going to trial. So I'm going to hold off on how the dynamics of how the trial was set up and how I was set up and all the other stuff, because it seems like that's the only information you guys need right now.
Right now, I'm just trying to get the merits of the case figured out. And your answer to my question about what you thought you had to pay or didn't pay is super helpful. So thank you for that. Are there other facts that you can give me in your direct examination at this time before Ms. Du Bois begins her cross-examination? Anything else you want to tell me about your claims against them, their claims against you, as it relates to the pleadings on file? That's all I'm asking for right now.
Yeah, other than my countersuit and my demand, I just need to give...
Tell me about that as well. This is your opportunity to tell me about the claims.
So the countersuit, I've met Jennifer Alvarado's children, and they seem very... They're raping children around here.
Your Honor,
okay, so hang on a second. So if there is a criminal allegation, I do not have jurisdiction over criminal cases, and this one is not involved in a criminal case. There's no notice to the family and so forth. So I'm not going to entertain any
criminal,
right? Because I don't have authority to do that. That's not up to me, right? And it's not part of your eviction case. So I won't entertain any of those claims that relate to criminal activity, and you have several of them in your list. But I can't. Yeah, I can't do that before you. I can't provide that relief. Now, that's
I'm not worried.
Without prejudice to you going to the appropriate authorities related to your criminal allegations. That's between you and the police and the DA and so forth. You can do it in another forum. You just can't do it here. So all of the causes of action that you spelled out earlier that relate to criminal cases or criminal investigations, we will not deal with those today. And any request that you've made in connection with something criminal will be denied here because I simply
I'm not worried about that.
Okay.
That was the initial countersuit, and it's in conjunction because it's relative because it's my residence and the players involved.
I understand why it's important. Yeah, I get why it's important to you. That makes total sense. I just wanted to be clear. I do not have the authority to rule on those. So all of those requests will be denied. And while we're on the subject, I couldn't, even if I wanted to, grant relief in the $200 million range because
I think it's 10 million here. Well,
It exceeds the jurisdictional limit of the county court at law, and I'm sitting as a county court judge at the moment, so I can't do that either. So what I'm asking you to do is just to finish up your testimony. If there's anything else you want to tell me related to the eviction case, because that's all the authority I have at the moment.
yes, and that's why there's a motion to escalate the case, because this is not a civil case. It is a civil case, but there's also a countersuit, and that's why there's literally a motion to escalate to a higher court, a district court, a federal court. To be
Well, you
honest, I
can
actually said
file-
federal court.
You can file those cases in the appropriate courts if you
Mhm.
like. That's up to you. We won't be dealing with that in this case. So all of your
But there-
requests related to those will be denied. But
There's a motion to
you could-
escalate, though.
you can, well, I'm not familiar with such a concept. If you
I'll
have a
show you.
criminal, if you have a criminal case, you go talk to the criminal people. If you have a federal court case, you go talk to the folks in the federal courts, right? So my point is, I am only dealing with this eviction and the related issues to the eviction, and I want you to finish up your testimony because I want to hear all that you have to tell me related to the eviction case, and that's it. Okay, so finish up your testimony on that, and then we'll proceed.
Yeah,
Okay.
we can proceed. Let's see what else is there. Let me check my notes here.
Yeah, take your time.
Did I mention the date of trial set and how she wasn't able to furnish any?
You did.
Okay, yeah, that's it. They've got all my. It's cut and dry. The document and then the conjunction of it with the other document. Here we are.
All right.
And then
So
the rest of it I can tell you about.
If you're done with your testimony on the facts related to the eviction, then I'll let Ms. DuBois ask any questions if she has any for you. All right. Ms. DuBois, your opportunity for cross-examination begins now.
I have no questions for Mr. Waeh.
Okay, so she doesn't have any questions for you. And I think I've asked you for the clarification of the things that I wanted to ask about in terms of the payments and all that. So I think I don't have any other questions either. Is there anything else related to the eviction case, Mr. Waeh, that you want to offer at this time?
Can I talk about the stuff that I wanted to talk about, or are we waiting for another time?
Is it related to the eviction?
It is related to the eviction, but you just
It's
told me not to
related
talk about it.
No, I'm telling you now is your chance to talk about the facts related to the eviction issues. Did you pay your rent? Did you owe rent? Did you not owe rent? Were you
Yeah.
required to post a bond? Did you
Yeah.
post a bond? Did you pay into
Yeah,
the
I filed
record
all.
report?
Yeah,
Did you
perfect. Yeah,
not?
let me just summarize.
Those
It's
are
30
the
seconds of a
facts.
summary. I
Let me
paid.
finish, please. Those are the facts that I want to hear about related to the eviction. The motion related to the setting of the hearing or whatever your complaint is about that, the jury demand, those are not things that I'm interested in hearing about right now. We can talk about that later. Right now, I'm only interested in the facts related to the specific issues around the eviction. So anything else about that?
Yeah, it's a fact that I proceeded with the legal proceeding, or I was conducting the legal proceeding accurately. It's a fact. It's a fact that I interpreted the information from the original petition correctly. It's also a fact that I had clarification from the JP courts or when we escalated. So I have these documents to protect me as far as those go. Everything else, I guess I can't talk about until you're ready for me to talk about.
I want you to talk about anything else related to payment of rent.
Yeah.
Like if you made
Yes,
a
ma'am.
payment, I want to know about it. If you didn't
Yes.
make a payment, I want to know about that. I want to know about anything related to the eviction case before we move to the next thing.
Yeah, that's it. I have my documents on file.
All right. Anything else, Mr. Boyd?
Your Honor, I have no questions for Mr. Waeh.
All right, that will conclude the evidence phase of our trial on the eviction. We will now move to
I can't even hear you.
Yeah,
Hello?
I think the judge is frozen. Hang on just a second.
Okay, thank you.
Yeah, because I see everybody else moving except for her.
Man. But hidden appeal and then I send this to New Western District. Screen processing, live screen processing Zoom stopped due to an Oh, can you still hear me?
Mr. Waeh, we can still hear you. We need to get our
Yeah,
connection. Yes, I can still hear you.
Awesome.
Hello?
All right, Judge, where you left off at before you froze, you were saying this will conclude the evidence phase of our trial on the eviction. We will now move to, and then you froze.
Okay. All right, closing arguments is what I was saying. So now we're going to essentially closing arguments, Mr. Waeh, is just an opportunity to summarize the facts and apply those facts to any legal arguments, right? Like state the statutes that might apply or legal theories or cases that relate to the arguments for why I should grant or should not grant the relief that's been requested. And once we finish with both sides closing arguments, we're going to take up these other issues that you want to talk about to the extent that they're relevant for us to do so today, particularly the motion to transfer and whatever else. So we'll get to that in a minute. Right now, closing arguments on the eviction itself. Ms. DuBois will begin, and then we'll hear from Mr. Waeh. And because she's the plaintiff, Mr. Boyd gets to wrap up. Go ahead, ma'am.
Your Honor, the evidence in this case shows that Mr.
Oh,
Waeh.
wait, I'm sorry. One thing, let me just clarify. Mr. Waeh, since you indicated that you don't have anything else, I just want the record to reflect correctly that you have rested your case subject to your arguments on the other motions before the court, like the transfer and so forth. Is that correct? You rest your case at this time?
Yes.
All right. Okay, go ahead for closing arguments, Mr. Boyd.
Your Honor, the evidence in this case shows that my client has a superior right to possession. There's a lease contract between Mr. Waeh and Estancia Villas that has been offered into evidence. There's evidence that Mr. Waeh failed to pay rent beginning September 1 of 2023, which is a defaulted lease. That defaulted lease allows my client to possession of the premises. In eviction suits, that is the sole issue for the court to adjudicate. There are no counterclaims. Mr. Waeh failed to pay rent, and so my client is entitled to possession of the property. They're also entitled to the back due rent that is owed to them. And the evidence showed today, Your Honor, that because he has not paid for each of those months, Mr. Waeh is liable to my client for $8,136. Your Honor, the contract between the parties.
So let me stop you there only because I just will need to clarify whether or not you have any rebuttal evidence to Mr. Waeh's testimony. You didn't tell me that you did, so I moved right to closing arguments, but now you're making an argument that he owes X dollars, the $8,000 sum, for example, as opposed to some other number, because his testimony was that some amount of money, roughly $4,000, was paid on his behalf. So you didn't ask for any opportunity for rebuttal evidence, but I want to make sure that you've got that opportunity should you need it before we wrap it up. Or are you simply relying on the evidence in the record, given the pay record?
Yes, Your Honor, I'm relying on the evidence of both my client's representative and the records and the exhibits that we've offered.
I just want to make sure that everybody has every opportunity they're entitled to. So, all right, with that, then, Mr. Waeh, what she's saying is she does not want the opportunity to add any rebuttal testimony to what you testified to. So what I have in the record is what I've received so far in terms of the testimony from the three witnesses, as well as the documents that were introduced and admitted into evidence. And with that, you may proceed with your closing argument, ma'am.
My closing arguments are
no, her. She was wrapping up.
Oh, sorry, I apologize.
I said, ma'am. Sorry. Go ahead, Mr. Boyd.
I didn't even hear you.
That's okay. Go ahead.
Your Honor, the contract dictates that my client is entitled to an award of attorney's fees here, and we properly presented evidence as to my client's entitlement to $2,600 in attorney's fees. Your Honor, my clients testified that Mr. Waeh has failed to pay rent. Mr. Waeh is the person responsible for rent under the lease contract. There's evidence presented to the court, that testimonial evidence that he failed to pay rent, any rent, except for $720 at the beginning of his tenancy. And this is also proven by Plaintiff's Exhibit 5, which was the ledger showing that Mr. Waeh only paid $720 when he moved in. No other entity has paid, no other payments have been applied to Mr. Waeh's account with my client. And so, Your Honor, this is a simple non-payment of rent case. There's additional reasons for which Mr. Waeh has defaulted under his lease that my client has provided as well, which is the conduct-based violations that was pled. There's evidence on file to show that Mr. Waeh was arrested for a criminal harassment charge that is a breach of the contract and therefore a default under paragraph 23.1b. And so again,
let me ask you about that. Hold on, let me ask you about that. Does your lease agreement indicate that anybody that is even arrested, even if they've not been convicted of something, is a violation?
That's correct, Your Honor. Criminal conduct under paragraph 11.1.
Well, it's not criminal unless you've been convicted of it, right?
Your Honor, he has been charged with a criminal offense of harassment.
But that doesn't mean he's guilty of it, right? I mean, people get arrested all the time and then they go to trial and they're acquitted. That doesn't mean that in fact, that means the opposite of criminal activity. It means they've been acquitted of what they were accused of. So I'm just trying to understand if your contract with Mr. Waeh says that he has to have actually committed criminal conduct or simply that he's been accused of it.
Your Honor, the lease contracts prohibits a tenant from engaging in criminal conduct. And then under the defaulted lease provision, it provides that it is a defaulted list of the lease for you or any guests or occupants to violate the lease, criminal or other laws, regardless of whether or where arrest or conviction occurs. In addition, Your Honor, 11.1b prohibits engaging in disruptive, harmful, loud or obnoxious behavior. My client testified concerning that conduct, as well as threatening conduct against others, including staff. That was 11.1c. My client testified concerning threatening conduct.
Objection. Hearsay. Where's your evidence? Where's your evidence?
Mr. Waeh, hang on. I'll overrule your objection because we're not in the evidence phase. She's not offering evidence at this time. She's just summarizing what she believes the evidence has shown, not giving evidence. So that's the difference. Go ahead.
Ms. Cantu also testified about Mr. Waeh's conduct of the property prohibiting or affecting their business operations, which is a violation of 11.1D. And so for these reasons, these violations of the lease are a default under paragraph 23.1B and is another basis for my client to seek possession and terminate Mr. Waeh's right of occupancy of the premises. So at this time, Your Honor, it is my client has the superior right to possession based on the contract, and they are seeking the amount of back due rent and attorney's fees, and we'd ask that the court enter the judgment that we have proposed.
All right, thank you. Let me ask another point of clarification. You've indicated the back due amount that you seek, which, if I understood your calculations correctly, were calculated by multiplying 1356, which is the amount of the monthly rent, times 6 months. Was that correct?
Correct, Your Honor.
But I didn't understand, and if I understood your calculation earlier, you calculate that number to be $8,136, correct? I didn't check your math. I'm asking about that now. And just so you can know where I'm headed with this, if that's the calculation, I don't see where you have given Mr. Waeh credit for the $720 you all admit he paid. And so would it not be?
Your Honor, this is just for the non-payment of rent. In eviction cases, we can only seek a judgment on the non-payment of rent. And so the $720 that he paid at the beginning of his tenancy would have been for prorated rent for the month of August.
Objection.
I see. So you're not
Objection.
asking for, hang on, Mr. Waeh, I promise you're going to get your turn. I'm just asking her to clarify what she's asking me to do, and I'm trying to check her math. So let me get clear with her about what she's asking for, and then you can give me your closing argument. So that I'm clear, the $720 that he paid, that you all admit that he paid, was not applied to September, October, November, December, January, or February, because it was not due for those months. It was due and paid prior to September of 2023. That's the position you're taking?
Yes, Your Honor, and that is evidenced by Plaintiff's Exhibit 5.
All right. Now, I just want to clarify all of that so that Mr. Waeh understands what happened to that 720 and whether or not it was credited or not credited. And I want to understand that so that I am clear about what you're asking me to provide you a judgment for. Okay. Thank you. Anything else?
No, Your Honor.
All right. Very good. Thank you. Mr. Waeh, it is now your opportunity to give me your closing arguments, and you may begin your closing argument at this time.
Yeah, so I moved into Estancia Villas August 21st, and I had paid the $720, fell on some hard times, and there was a delay in payment on my behalf. UDR, a $15 billion corporation, proceeded to collect the asset of Estancia Villas or Steadfast Management. They changed everything up. So September 15th, I couldn't even pay rent. Nobody in the 341 buildings here could pay rent until around September 15th. On the 25th of September, Jennifer Mercado showed up and gave me a notice to vacate. Keep in mind that I had moved in with rent paid, $720 advance deposit and everything for September, for the 1st of September. So between the 1st of September and the 15th, I wasn't even allowed to pay. And then 7 days, or not even 7 days, 10 days after that, she shows up with a notice to vacate. I didn't even get 1 month to do anything. It was just a notice to vacate. In addition to that, I made multiple attempts that I do have on record and on file to pay a portion, even being 80%.
Your Honor,
of the
I'm
rent.
going to object just because there's no facts into evidence or testimony in
It doesn't matter.
ways.
I'm going to overrule the objection.
Yeah, I'm just telling the story. I'm summarizing.
Yeah, but Mr. Waeh, let me just point out, technically she is correct in that your argument must relate only to those things that were produced in evidence already. And what she's arguing is this is new information. I'm just going to ask you to tell your story based on what we've already discussed. I don't want you to.
Okay, I hear you. Well,
all right, go ahead.
Yeah, for sure. I got you. There's a book on file as far as the e-files go, and all of my motions and documents. Everyone's been overlooking. This has been going on since December. This is the whole reason why everything's becoming complicated now. There was just literally an eviction appeal. It went to another plaintiff petition for JP courts, and now there's like 10 involved. You have been assigned to be the judge on all cases in the with respect to Travis County at law. So essentially, it's like a cluster. I don't want to use the word here, but basically what I'm trying to get at is that all of my documents, including what I just mentioned, was on file. The judge could have seen it, Aaron could have seen it. And when I say that, I have literally written a book on this, what my experience has been. And it includes me showing up on August 21st and then not having the ability to pay rent until the 15th, and then getting a notice to vacate on the 25th. And then after that, having a month before trial, and then it being paid on my behalf because they've been monitoring me inside here this whole time. And then boom, the original petition in conjunction with my appeal. And that's why we're here right now. And just to further reiterate, there's a demand for a jury trial on here. I know that now is the appropriate time to talk about it. So as pro se, I was able to file that electronically through email. That should suffice as far as me requesting, because I have 4 subpoenas literally delivered by the constable through the same channel. So it doesn't make any sense for my demand to not be on there. In addition to that, when I came out of jail, this is the main thing right here. Judges, I know you can't overrule it, but I'm mentioning it because it's a fact. Like the trial that's being handled right now is inappropriate. For one, Angela told us that this is going to be a hearing. So I'm
Well,
not
Mr.
prepared
White,
because
on
I was
that-
under the
on that
impression
point- But hang on that point, if you look carefully at what you received from Ms. Burks, which you shared with us on your screen, it
there's another
says
one prior to that. I hear you.
what you shared on your screen, which you asked me to read, which I did,
Mhm.
indicates very clearly that in addition to your motion to transfer and other matters, today you should be prepared for a hearing on the merits. That's spelled out in the notice that you received. I just want
Well,
you
with
to
the jury trial. With the jury is what I was talking about. I'm sorry. That's what I meant.
you meant that it was a hearing, and I was reacting to your point about it's a hearing and not a trial.
Mhm.
I just wanted to point
Yeah.
out that the notice that you shared with us this morning very clearly indicates it's going to be a hearing on the merits, meaning a final trial on all the matters related to the eviction case. I just wanted to point that out. Go ahead.
Okay. Yeah. So there's supposed to be a demand. It's supposed to be a demand trial. And what I'm trying to get at is that the fact that like they've been doing a lot of sneaky stuff. So Aaron mentions, oh, well, this dude, he broke the lease. He violated the lease by committing a criminal act. First of all, I haven't even been proven guilty. I have a whole lawyer and they're about to dismiss the case, to be honest with you. I'm just saying. Independent of that, I have information relative to the case. Hold on. I don't even know how to put this.
Well, let me stop you by saying, as long as it relates to the eviction case, if it's about some criminal conspiracy or something else,
That's what I'm trying to stay away from. Yeah.
Yeah, stay away from that. Just give me your closing argument on the eviction case.
I'm just trying to get at the trial wasn't set appropriately because had I gotten out of jail, Aaron still cannot furnish any notice like, hey, we're letting you know that there's a trial. As soon as I get out, they're just like, hey, there's a trial. And then they reset the trial and I let them know that there's also a demand. At the point where they reset the trial, they should have also considered my demand for. So the 17th, due to weather, inclement weather and pipes bursting, for one, they couldn't even provide notice to me, the defendant, that there was a trial in state and I just gotten out of jail. There was no fair warning or anything like that. They're just like, hey, there was an act of God. Literally, the trial is reset. Now they're already aware of my demand for the trial and they just reset it. Here we are. They reset, they had the opportunity. And I've told everyone, not just you, Aaron, Colton, everybody, there's a roster of people that have been stressing out, sending emails, linking emails, e-filing for this demand trial. On the 18th, not only did they not provide anything prior to that, as far as setting that trial, but then they also, in conjunction, the same violation that I went to jail for, Aaron and all of the representatives here decided to imitate and mimic that with Travis County Sheriff's Office and then literally got declined. So I went to jail for harassment, trying to plead my case. I get out, they file another harassment charge on me and then get declined on it and then literally try to spin the argument and then without any notice, try to set trial. Then they reset trial and then they say hearing and I have a demand trial since the 11th. And not only did I file this thing on the 11th, but Travis County's website says within 48 hours, they're going to process. So they actually accepted it on the 16th of January, 2024. They let 3 days extra elapse. What I'm saying is I've been on top of it as far as submitting my documents in the proper way. And basically they've just been overlooking it and trying to do other tactics in conjunction with different departments to minimize me and prevent me from speaking. There's a lot going on here. Now, in regards to the other, if I can share my screen with you again. Here it is right here. It says Judge Livingston has been assigned. Can I share my screen?
Yes.
Okay. Share screen. Start broadcast. Okay. So it's a little blurry, but the state of Texas, they basically assigned you to all the other cases. It's almost because the cases piggyback off each other.
Okay,
And
so
I filed
Mr. Ray, hold on. We're going
Go
to
ahead.
deal with other cases another time. We
Sorry,
can
I didn't know
talk
this
about
was the
that
time.
No, that's all right. We're going to deal with those at the end of the hearing because we can clarify what happens in those cases. As I understand that order, it only mentions this one cause number, but we'll clarify that later. Right now, again, I just want you to stay focused on the eviction case.
Okay. So yeah, here goes their notice. There goes Jennifer, aka her name's technically Amanda. I'm telling you, she told me, it's not even relevant at this point. It is kind of, but she shows up with a notice and here it goes right here. Can you guys explain this right here? There's literally nothing that I've done, making inappropriate or derogatory remarks. They don't have any evidence of anything. That's what I'm saying. So they're just trying to do character assassination at this point in time. Not only did they swindle the system and do all kinds of stuff, get trial set without any notice or anything to me while I was in jail and I was providing documents, they also can't provide where and when I did any of this stuff right here, especially considering the initial petition, how it didn't have any lease violations on it. And then fast forward to this time right here, December 6th. There's literally like, what have I done? And can you please elaborate and explain and document it and put it on camera, please? Because you can't just say that. It's character assassination.
Mr. Well, hold on. When she makes an objection, you need to stop. But before
I didn't hear it. I'm sorry.
That's all right. Don't worry about it. I need you to focus just on the eviction. And you don't get to ask any questions of her at this moment. So move on.
Okay. Yeah. And so just in summary, basically, It's just a mistrial. It's a mistrial from the very beginning when they processed it without any legitimate cause to evict me. And that's what the appeal was for. I was in a position, things were paid on my behalf. It's literally a document. And the document isn't even 100% accurate because they forgot to add that $720, unless it's just for unpaid rent, in which case they still put the $4,068 as claimed rent as of that time. There is no pursuit for unpaid rent, and there is no pursuit for applicable attorney fees. In addition to that, the document that I have for surety, approved by JP3 and escalated to Travis County, and also signed off by Estancia Villas at that time, it basically minimized my $1,356 rent payment to $0 to the JP court at the time of court, in which case I actually demanded a jury, so we shouldn't even be here in the first place, is my argument. And that's it.
All right,
now.
thank you.
Yes,
Ms. Du Bois, anything further? Mr. Waeh, if you don't mind stopping your screen share, we'll hear
How do
from
you do
Mr.
that?
Boyd. Just hit that red stop share button. Thank you. Go ahead, Mr. Boyd. Anything else?
Your Honor, again, the facts and the evidence presented to you today show that my client has a superior right to possession. Mr. Waeh has now argued that he was not provided notice. In the court's file is a file marked copy of a notice of hearing and trial for January 17 that was served on Mr. Waeh on the email address that he provided to the court in his statement of inability to pay. There's simply no defenses that Mr. Waeh raises that do not entitle my client to possession of the property, as well as the amount of rent that he has failed to pay. And so we'd ask that the court enter judgment in plaintiff's favor.
Thank you. Just another point of clarification, Mr. Boyd. Do you have handy, and maybe you could share your screen, a copy of your pleadings in the county court filings so that Mr. Waeh can see what you spelled out in terms of your request for unpaid rent, attorney's fees, and other matters? There seems to be some confusion, and maybe the confusion's on my part, perhaps, and maybe everybody else is clear, but I think it appears to me that there may be some confusion about what your client requested in justice court versus what you've requested in the trial de novo. And so I just wanted to be clear so that I'm clear, because it's my understanding that when you get to the county court and you file pleadings on file in this trial de novo, this new trial in the county court at law, at that point, your pleadings can ask for any number of things that may or may not have been part of the prior proceeding in justice court. And so I think there may be some confusion about that. And I thought it might be helpful if we just kind of scroll through that petition. And so if you'll just slowly scroll down to the requested relief and the allegations regarding unpaid rent. So let's stop there. So we can see now on page 2 of the plaintiff's petition in county court, there are allegations of a breach of contract of the lease agreement for the non-payment of rent and other sums of money. And if you'll scroll down further on that same page, there's also an allegation of breach of contract for other prohibited and criminal conduct, which we've discussed. And if you'll scroll down further, you'll see in the county court filings by the petitioner, they describe what they believe are violations of the lease. Keep going down, if you would, please. And then there's also a request for attorney's fees. Keep going. And then at the end there on page 3 of the petition filed by the plaintiff in the county court petition, there is also a request for judgment that asks for forcible detainer, immediate possession, and so forth. And then if you'll keep down now to page 4 there's a requested relief that asks for essentially everything they've spelled out. So you can stop your share now. I just wanted some clarification so that we're all clear that what the plaintiff requested in the JP court may be, can be, and apparently is different from what they asked for here. Sometimes that's because landlords are interested in just getting their property back so they can rent it to somebody else, and they're willing at that point to just forego the rent because what they really want is to be able to rent it to somebody new. They cut their losses, if you will. That's sometimes why.
What I'm saying is that
I'm not done.
Oh, sorry. Go ahead.
And so sometimes that's what's done. I don't know if that's what their thinking was here or not. I don't have any evidence about that. I'm not making any decisions about them. I'm simply pointing out that that explains sometimes why what we see in justice court might be different from what we see in the county court proceedings. Here, it's very clear that in the county court proceedings, the plaintiff's petition does in fact ask in writing in their petition for everything they've asked for here today. So there seemed to be some confusion about all that. And I just wanted to clarify that. Second thing I want to clarify is that the affidavit of inability, and again, I don't know what people were thinking or what was in their understanding, and I'm not making any decisions about that because there's no evidence to me about that, and it's not something I have to decide necessarily. But I would point out that often there is confusion by folks about the affidavit that indicates that you don't have the ability to pay the appeal bond or the surety bond. As I understand the law, that does not absolve you of an obligation to pay your rent into the registry of the appropriate court. It has effect related to your inability to pay the appeal bond or the surety bond. Those are really two completely separate and different. Mr. Waeh, it's my turn. Two completely separate things. So I realize that here lots of things going on and people have different understandings about all of that. The way to resolve that, if you are unhappy with the decision, like in the JP court, somebody was not happy with that decision, you appeal that to the county court. The county court makes a decision. If you are not happy with that, you get to go to the next level court, the Court of Appeals.
Perfect. Yeah.
And then beyond that to the Texas Supreme Court. So there are checks and balances, and there are opportunities for either party to go to the next level, if you will. If you're not happy or satisfied, or you think that there was a legal error in the court you're in, you have the opportunity to have that reviewed by a higher court. And so I know I said that earlier, and I think it bears repeating, just because I want to be clear that everybody has multiple opportunities to have their day in court and get their issues heard and resolved. And that's true for the decision on the merits. That's also true for these preliminary rulings, like the motion on the jury trial and so forth. So there is and will be ample opportunities to flesh all that out in the appropriate forums. Now, before we get a ruling and we wrap up for our time today, we still have a couple of other things to talk about. Mr. Waeh, tell me, if you would, what your motion to transfer is about. Once you've done that very briefly, then I will hear from Ms. DuBois about why she thinks it either should not be granted or is not timely. I do have a concern because I believe that those motions, depending on the nature of the motion and what you're seeking, is something that might have been dealt with prior or should have been dealt with before today. I don't know. Tell me what it is you're requesting in your motion to transfer.
Yeah, the motion to transfer is strictly based on biased decisions made by Travis County at Law 1. That's what I need to get out of Travis County at Law 1, because you guys have been taking advantage of me seriously. For one,
Okay.
the
So
reason why we're
wait,
here.
hold on. I just want to know the nature of the motion, not all the details why you think that motion should be granted. I'm not asking that question at the moment. First, I'm just asking, what is it that you want in your motion to transfer?
First of all, I wanted this to be an actual hearing, actual trial, not a hearing. And I wouldn't have done it online because I wanted to do it in person. So the reason to transfer the case was because they put an order of constraint that was vague, that
You want
wasn't
to transfer
specified.
what to what is my question. What do you want to transfer?
I want to transfer this case to another county. And I also there's another motion to escalate higher. So there's a motion to escalate higher, and there's also a motion to transfer out of Travis County because they've been biased. And I've also reported that judge to the State Commission on Judicial Conduct. I've reported him already.
Okay,
On
so
top of
that's
that, he's recused himself.
hold on. So that's what I was asking. What is it that you want to transfer from what to what? Because
I want to transfer this case.
Right.
This case
so
wasn't even supposed to be conducted here because it's biased.
I just want to clarify what the motion is about. And just so I'm clear, I'm going to repeat back what I understand you're saying. You wanted this cause number, this CV 23005479 case, to be transferred out of Travis County to some other county in Texas.
Exactly.
Okay. All right. That motion is denied. I don't need to hear argument about that because I do not have the authority to do that. We have jurisdictional rules, venue rules, and compulsory venue provisions and mandatory provisions related to where a case must be brought. And it's very clear that a Travis County property and a Travis County eviction must be brought in Travis County. So I don't have the authority to do that. However, as I've said, if that decision that I've now made denying your motion to transfer out of Travis County to some other county is a decision that you're not happy with, that again is something that you can take to the Court of Appeals. But for today, I simply don't have that authority. So I'm going to deny that motion to transfer.
Your Honor, for purposes of the record, I just want to also point out that Mr. Waeh filed the motion to transfer venue on February 2, and pursuant to Texas Rule of Civil Procedure 257, due to his allegations of bias, he would have had to have signed that by affidavit, as well as have at least 3 credible persons in Travis County attach affidavits to that, and he failed to do so.
All right. That motion is denied. So I can't deal with that. Now, there are another matter related to some other cases that you have pending in Travis County. Is that right, Mr. Waeh? Okay,
yes, ma'am.
So let me here's what I want to say about that. I am aware only of this cause number related to the eviction with Estancia today. What I would ask you to do is first confer with whoever is on the other side of that case, whoever's representing who you're suing, or if they're representing themselves, email or call or coordinate with those folks and with Angela Burks to clarify 2 things. 1, what's the cause number? Or a couple of things. 1 is what's the cause number? 2, when are you all ready for a hearing or a trial or whatever proceeding you need me to preside over? When are you going to be ready to do that? And then send in to Ms. Burks, Angela Burks, whatever matters you need me to hear. So if it's a trial on the merits, fine. If it's a trial, then I can have access to the pleadings and so forth. If it's a hearing on a preliminary motion, for example, fine. Just let me know. She will let me know, but I need you to confer with whoever's on the other side of that case so that it's clear what other pieces of litigation are pending that you need me to hear. And then I will clarify my assignment with the regional presiding judge about whether or not I'm needed and assigned to those other cases. But the first step is for you to communicate with whoever's on the other side of those cases to figure out, are we ready? What are we going to hear? What do we need the judge to do? And when can we be ready for those things to be heard so that a hearing or a trial or whatever can be scheduled on those matters at a time that's convenient to my schedule and to your schedule and to the opposing counsel's schedule. So that's the first thing that you can do. And when you've communicated that to Ms. Burks, she'll let me know that so that I can then work with her on a scheduling issue so that we can all be here and available at the same time. And we can do that either in person or on a remote hearing. Either one is fine with me, as long as it's a convenient date and time for everyone that's involved. So that's what I wanted to say about those other matters that are pending. The final thing I want to say about these sort of other matters is Mr. Waeh mentioned that he wanted to have something happen in person. I just want to point out that I was told that a remote hearing was requested. I don't know if
For
that's
the hearing,
accurate.
not the trial.
We use the terms trial and hearing interchangeably, particularly when we say on the merits. That means the whole shebang to us. So I appreciate that that might not be precise and that might be confusing. I get that. But when you are told in a note or a notice that the merits are going to be decided, that is a final matter, right?
Okay, then I had objected to
Call it
that,
a trial.
to the case.
I'm not arguing about it. I'm just telling you
Okay.
what I was told. That's all. My point here is in offering clarification and explanation for what I'm doing and why I'm doing it, because that is the information I was provided. I'm not saying it was accurate. I'm not saying it was correct. I'm just telling you that's what I was told. So I was told we were doing a hearing on the merits. I was also told that the parties agreed to a remote proceeding, and that's why we conducted it remotely. I was perfectly happy to show up in person, but I was told that the request for a remote hearing, and so that's why we're having this hearing in a remote venue. All right. So that's the information I have regarding all of the other matters. I don't believe there are any other sort of other matters other than the merits of the case. And
There
if
is
there
one.
are, what's that?
It's that considering the original petition, there should have never been an eviction to begin with. We shouldn't have even been here. So anything after that point, now you're asking for all types of stuff, is nonsense, because there was zero cause in the first place. You can't even be here, is what I'm saying.
I understand that that's the position that you take, and that's one of the reasons why I wanted Ms. Du Bois to show us her petition so that you could be clear and we could all be clear that when you get to a trial de novo in the county court, which is where you are now in the county court at law, you get a trial de novo, meaning a brand new trial with brand new pleadings, a brand new request, and brand new allegations, even perhaps.
Well, having said that, they didn't subtract it.
Stop. Let me finish, please. So that's one of the reasons why I wanted to go through that process of going through the pleadings, because everything in that pleading is before the court. I understand the position that you're taking about feeling like you hadn't done anything wrong, feeling that, people were had it in for you. I understand all that you've testified about that, and I'm taking that into consideration. I'm simply pointing out that all of the issues are before me at the moment, and I'm going to make a decision about that. And I want to just clarify there's nothing else other than the merits of the eviction case now that has to be decided. Is that right?
Your Honor, except for our motion under 510.9C.
Well, that includes one of the requests you're already asking for, which is immediate possession. That's redundant to what you're already asking for in the case. So I think we'll get that.
Okay.
It'll be subsumed.
Well, you guys are surely getting appealed.
Just
Just know that.
So stop, Mr. Waeh. Hang on. She's trying to clarify something. Excuse me. She's trying to clarify something. I just want to be clear about what she's asking me for. I appreciate that there are different avenues to the same location, but I'm going to deal with all that you've asked for and cover all the requests as it relates to the substance of the eviction. Is there anything other than immediate possession, rent, attorney's fees, and the criminal conduct?
Demand,
is there anything else? Excuse me. Is there? Oh, please, you both have to wait until I'm finished, because A, it's just rude, and two, Ms. Duet can't take it down when we're all talking at the same time. Let me finish, please. I'm simply asking if there's anything else other than related to possession and rent and so forth and all that. Is there anything else that we've not dealt with that is supported by a pleading on file in this case? Yes or no?
Your Honor, I just simply want to clarify the plaintiff is requesting the judgment be signed as well as the order for immediate possession. That is all.
I understand that. I think that relates to the substance of the eviction. That's going to get dealt with. Is there anything else?
For sure.
Is there anything else, Mr. Boyd?
No, Your Honor.
Is there anything else, Mr. Waeh?
Let me ponder for a second.
Okay.
To the merits of the eviction, without anything else? Yeah, without anything else, nah.
Okay. All right. Then
Just the original petition.
Sorry?
Just the original petition and where we are now with respect to where we are now.
Yeah, you've made that argument. I understand
They
that.
need to dismiss the case, to be honest, and restart and sue me for rent is what needs to happen.
I understand your position about that. I get that. I understand. You've made that real clear. I understand that. I think Ms. Du Bois has made her client's position very clear. I get that.
Mm-hmm.
I am now going to rule on that because I think we have dealt with everything else.
Mm-hmm.
Make sense? Okay. All right. Here we go. First, the plaintiff's request is granted in part and denied in part. The part of the plaintiff's request that is denied is a judgment and eviction based on this allegation of criminal conduct. I simply think there is insufficient evidence. Mr. Waeh, I need you to mute your microphone, because you're editorializing and I can't have that interruption, please. Just mute your microphone if you would until it's your turn. Okay. So the part of the request by the plaintiff based on criminal conduct is, I believe, insufficient evidence to prove that, and so that request is denied. The part of the plaintiff's request that is granted is in all other respects. I do not find credible evidence that rent was paid when it was due. There is ample evidence that Mr. Waeh paid only $720 in the month of August of 2023, and that he has not paid a penny since then, even though the lease agreement requires that he pay $1,356 per month. Those payments were due on the first of the months of September, October, November, and December 2023, and January and February 1, respectively, 2024. And there is no evidence whatsoever that he paid any of those sums. I believe that Mr. Waeh thought that he was not required to do so. I don't believe that he is correct about that. And so I do find that he owes the sum of $8,136 for 6 months of rent at $1,356 per month, for a total of $8,136. He's not paid that sum. He owes that sum. And so judgment in favor of the plaintiff is granted in that amount. There is some testimony by Mr. Waeh that some roughly $4,000 or so, $4,068 was paid on his behalf by the representatives of this big corporation that owns the apartment complex. I do not find that evidence to be credible. And so I don't think that the managers who are employed there seems unlikely to me that they would be paying rent on a tenant's behalf to the tune of $4,000. I simply just don't find that credible. And so I'm not going to give that any weight. Mr. Waeh moved in. He hasn't paid the rent from September to now. He owes it. Judgment is granted for the plaintiff in that amount. There was a request for court cost. I'm going to deny the plaintiff's request that Mr. Waeh pay those. I'll order that each party pay their own court cost, if any. And so if you have court costs, you pay your own court costs. There was also a request for interest, sort of in general, on the sum that I've now ordered the judgment for, in the $8,000 amount. I will not order any pre-judgment interest. I will order post-judgment interest until that sum is owed is paid in the amount of 6% per annum. There was a request for attorney's fees since the plaintiff has prevailed on their claims, at least prevailed in part on the request for the eviction to the tune, or to the on the ultimate issue regarding the non-payment of rent. So I do find that $2,600 in attorney's fees for all that's been done throughout the case is a reasonable and necessary fee, and will order attorney's fees. Those attorney's fees will be due and payable on or before April 1, 2024. That way I'll give Mr. Waeh some opportunity to pay that. He's indicated that he has a sufficient income. He indicated his income was in the $160,000 range. And so despite the affidavit of inability to pay the appeal bond, he's testified today that he has income sufficient to pay the attorney's fees. And so that sum will be due by on or before April 1, 2020. That's okay. You can object, but right now you got to pause your thoughts.
Sorry. I never said that. I just want to clarify. Gotcha.
Well, I'm sorry. That's what I heard. If I misheard you say that, or maybe
can I correct you?
Sure.
So the interception from Travis County Sheriff's Office prohibited me from maintaining my job.
You can correct me about what you said about the $160,000.
I was making $160,000. I had gotten the job as a high-end job. Travis County Sheriff's Office arrested me, which prohibited. I got out of jail and lost a $160,000 job.
You lost that job. Okay.
Yes,
ma'am.
Right.
Well, that's great. Well, I tell you what, then, based on that information, I will amend my order, and I will give you until May 31 to pay the attorney's fees. I'll give you a little more time to get that paid. So I'll change that based on that information. And thank you for clarifying that. I will order the payment of the $2,600 on or before May 31, 2024. I do find that the plaintiff has a superior right of possession and will grant immediate possession to them because they are entitled to it. And I don't think there's any, I think the evidence is clear that you can't rent a place, not pay the rent, and then continue to live there. So I do believe that they're entitled to immediate possession. And I believe that the writ requested by the plaintiffs in that regard for immediate possession is both justified by the evidence and appropriate under our law. Let me just check and see if there's anything else. I think that's everything that covers all of the requested relief. To the extent that Mr. Waeh has counterclaims on file, they're all denied because they are either in excess of the court's jurisdiction regarding the $10 million or $200 million in damages that he's requested for what might be considered tort claims. And then with regard to the criminal claims he seeks, obviously I do not have the jurisdiction to deal with those matters, but I think he understands that if he wishes to pursue those, he has other avenues, both in the federal courts or in the prosecutor's office or the police with regard to other matters, and I think he understands that. We've explained pretty thoroughly the right of appeal that each party has if they don't appreciate this proceeding and the rulings that I have made today. So here are the
How long
next
do I have to
steps.
appeal?
I can't give you, that's technically legal advice, which I'm
5
not
days?
allowed to.
Thank you.
I said I am not allowed to give you legal advice, and so I can't answer that question.
No worries. As soon as this is done,
Yeah,
as soon as
up
it's done.
up to you. I would say sooner the better, but I'm not allowed to give you advice about your deadlines because that's the
Mhm.
nature of advice which judges are prohibited from giving. So I can't tell you the answer to that, but I can generally say that the more quickly people do things, the better.
Gotcha.
So
We're
I'll say
going higher for sure. Thank you.
Okay, so here's the next step then, what will happen. Ms. Du Bois is going to be directed by the court to prepare the documents because she represents the plaintiff and the plaintiff is the prevailing party. Typically, we would ask the prevailing party to draft the documents. She will do that. She will send them to you, Mr. Waeh. She's going to send them to you by email. Ms. Du Bois, in your email, please indicate that you need them back within 5 days. So, Mr. Waeh, I'm going to give you 5 days to review the documents that she has sent to you. That should be enough time. You probably can do it sooner than that. I don't know what you may want to talk to somebody about. I just want to make sure you have enough time to think about it, review it, make changes or whatever. If you have changes to the document because you believe they are inaccurate, then redline the copies that she sends back to you and tell her, you don't want it to say this, you want it to say that, or whatever. So send her what you think that document should say if you disagree with what she puts in there, okay? Once you hear back from him, Ms. Du Bois, then send those documents into Ms. Burks, and then she will send them to me. I will review them and I will sign the document that I think accurately reflects my ruling today. Okay. And it should be a complete and final order, and be sure you include that language in it so that it's final and appealable and can go up to the next level. So, Mr. Waeh, she's only going to wait those 5 days. If she hasn't heard from you, then she's going to send that draft over to Ms. Burks, who will then send it to me.
I have not been able to communicate with Erin not one time since the trial.
It's just by email. It's just by email. You don't have to have
I have not been able to communicate with her.
Yeah, she is being directed to draft the document. You are being directed to send her your changes if you have any. You may not have any because she may get it right and correctly reflect it. Now, let me say 2 things about that. One, if she doesn't hear from you within those 5 days, she's going to send it on. If she does hear from you within those 5 days, she's going to either make the changes you've requested because she's agreeing to them, or she's going to then send to Ms. Burks her draft and your draft. You are also welcome to send her draft and your draft directly to Ms. Burks. You can do that too, as long as you do it within those 5 days. So everybody can send whatever they want to Ms. Burks, who will then send it to me within that 5-day period after Ms. Du Bois drafts them and sends them to you. I'm going to direct her to get that to you by Monday of next week, March 4th. Okay, so it shouldn't take her too long. She's required. Can you get it to him by Monday?
Turner, I can get into him in the next 5 minutes.
There you go. So no later than Monday, Ms. Du Bois is going to get it to you, and no later.
You have 5 days,
than
Erin. Calm the hell down.
Excuse me. And then Mr. Waeh will have until Friday of next week to make his changes. Everybody by Friday of next week must send what they've received by then to Ms. Burks. Okay.
So then after that point, you're going to initiate your order, and that's going to come from you.
After
then, right?
that point, I'm going to review what you have both submitted to each other. You're either going to submit an order that you both agree is correct, or you're going to say, I want this language, and the other one is going to say, no, I want that language. I am going to then review them both, and then I am going to sign the one that I think accurately reflects my ruling. And if you both get it wrong, I'll probably draft my own. But that seems unlikely.
I just want to clarify, the document coming from you, the judge, that's going to be the final document that I can appeal,
that's going to be the final order on the merits of the case that reflects what I've ruled today. That's correct.
Okay. And so when you initiate that.
Just to be clear, here are the deadlines. Ms. Du Bois has until Monday, close of business, to get the order to you. You will have until, I'm going to adjust that a little bit. I'm really going to give you 4 days because I want you to get it back to her by the end of Thursday of next week. So if you want to tell her you got changes to it, you have until the end of the day on Thursday to make those changes. I want by noon on Friday of next week for you all to send to Ms. Burks what you believe is a correct reflection of my ruling. Okay. I want that to Ms. Burks by noon so that she can then send it to me and I can look at it and get it back to you. I may or may not get it back to you that same day, depending on when I get it and what else I'm going on. Maybe a hearing that day. I don't know. But I want them to Ms. Burks by Friday of next week so that I can then review them and sign the one that I believe most accurately reflects my ruling. Now, Mr. Waeh, Ms. Du Bois, these orders, this order that we're talking about, should include only those things that I'm ruling on and the request that I'm granting, the request that I'm denying, all that we've discussed today. Mr. Waeh, when you react to what she writes, that is not an opportunity to re-argue the things that we've talked about, right? It's just an opportunity to make sure that what she puts in that draft order accurately reflects what I've ruled. right? To the extent that you've reconsidered, you want me to reconsider the jury trial, I'm not doing that. That's order stands.
Yeah, we're
until-
gonna escalate. Yeah.
to the ex- That's fine. That's okay. I'm just saying that the purpose of this order is just to reflect what we're doing, not an opportunity to re-argue. You can re-argue that in another case, right? In another.
Gotcha.
This order just needs to say, here's what Livingston is ordering. And that
Mhm.
way, when you go to the next level, that
It's
court
not
can
wrong.
say, oh, here is what Livingston did. She got it right. She got it wrong. But
Mm.
here's what she did. And so this order needs to say what I did, not what you all think about what I did, right?
Mm.
Not whether you agree with it or disagree with it. Just is this what I actually ordered? And that's all that needs to be in that order, not your opinion about it. Just did I accurately say denied, granted, ordered, amount of money, amount of interest, attorney's fees, whatever, right?
Mhm.
Speaking of attorney's fees, in addition to the $2,600 that's due on or before May 31, 2024, the appellate fees testified to in the event of appeal, those are granted as requested. And so that should be included in there as well. So again, we just need an order that says, okay, we had a hearing on February 29, 2024. Here is what Judge Livingston ordered. Yes, no, granted, denied, money, interest rate, so-and-so. That's what she did.
Argue.
And then I'm going to sign that. And then if anybody wants to appeal that, now the appellate court will know exactly what I did. And then they can decide, they can grade my paper, right? And
Mhm.
decide whether I got it right or wrong, but at least they will know exactly what I ordered and what I did not order. Okay?
Your
In
Honor,
the meantime, I'm going to get two things because the writ of possession is going to issue immediately. You can send that over to Ms. Burks today. You don't have to wait for that for next week. You can send that today because your client is entitled to that today. Send that to Mr. Waeh and then send that to Ms. Burks today. Mr. Waeh, if you have objections to that,
I have objections to that.
no doubt about it. But send your objections to Ms. Burks as soon as you get that.
Mhm.
And I will wait until later in the day to sign it, just to give you an opportunity to make whatever changes you think need to be made to it. But I will sign that one today.
As far as the eviction goes,
I will sign the order for immediate possession today because they're entitled to that. And then you have avenues that you can take related to what you want to do next about all that. But I want the order because they're entitled to it today. I want that one signed today. The other order can wait. Okay?
what about the property then?
You're asking me questions related to legal advice that I cannot give you. So I can't give you legal advice.
Okay, so I can appeal this, right?
Absolutely. Well, I believe that that's also a question about legal advice, but I think I've already said that my decisions are subject to being reviewed by a higher court. That court is called the Third Court of Appeals.
Okay,
Okay?
let me get on
All
my
right.
appeal then.
All right. Take care, everybody. It's nice to meet you all. Mr. Waeh, don't forget on those other cases, you need to visit with the opposing side for
I
that.
can't,
And then
Judge
schedule
Livingston,
that.
I've already
I can
talked.
hear you.
Hello?
Okay, I can hear you now.
Okay, I was just telling Mr. Waeh to be sure to deal with, talk to Ms. Burks on those other cases. And I believe that concludes our time today. Thank you. Good luck to all of you.
Your Honor,
And thank
may
you, Ms. Duet, for taking it down for us as the court reporter. Thanks to Mr. LaRue for handling the Zoom call for us. Appreciate your assistance as well. You all have a great day and we are adjourned. You may be excused.